Monday.
May it please your lordship, I beg to mention one IA for early hearing lordship. The matter may be listed on Tuesday.
May I please, your lordship, I am praying for listing one motion matter, lordship, on Wednesday, lordship. On
May I please-
24th, lordship.
May I please your lordship, for listing an IA lordship in MSC appeal lordship, can it be on Wednesday? IA for what? Lordship, actually, this honorable court has passed an order to release the fixed deposit, interest of the fixed deposit. Lordship, bank has not granted to
Wednesday.
Wednesday.
May I please, your lordship, I beg to mention item number 23, lordship. We have taken the consent from the other side, read home. Having the inconvenience, the Angus Council, Mr. N. Alam's close relative has expired, lordship. We pray for our accommodation for total.
Learned Counsel Mr. A. Day.
S.A. Bhakhtiar, for respondent one,
On behalf of Learned Counsel Mr.
N. Alam.
Alam, with the consent of the other side, has prayed for adjournment. This is the matter after puja vacation.
A date may be fixed.
Date. 13 November.
Much so.
May I please, your lordship? Lordship, I beg to mention item number 22, which I have taken consent from the other side.
Learned Counsel Mr.
SK Gupta on behalf of OP Bhatti.
S. K. Gupta, on behalf of Learned Counsel Mr. O. P. Bhatti, with the consent of the.
I am for the respondent.
Okay.
Lordship,
On behalf of Mr. O. P. Bhatti, has prayed for adjournment. Learned Counsel Mr.
B Devi lordship.
B. Devi is present on behalf.
S Burman lordship.
Learned Counsel Mr. S. Bormon, representing the respondent. What
Lordship.
is the matter after puja vacation?
After
Lordship, can it be on 4th of November?
On 18 November.
Lordship.
May I please, your lordship, with the consent of other party, I have beg to mention item number 2, lordship.
Item number 2. Learned Counsel Mr.
S. Fazil,
S.
S. Fazil. S. Fazil,
Now to with on behalf of
Mr. G. Jalan, petitioner.
Learned Counsel Mr. G. Jalan, with the consent of the other side, has prayed for adjournment.
My lord, I am for the respondent caveator, my lord.
Jalan, you have is present. Learned Counsel Mr.
J8 Sekia.
G. Jalan himself has prayed for adjournment. Learned Counsel Mr. J.
J8 Sekia.
Is present for the caveat respondent. Is the matter after puja vacation?
Can it be fixed on 15th October, my lord? There is urgency, my lord.
Yeah.
Lordship, it may be 27 October, lordship.
That after consultation, my senior suggested that 15th.
Lordship, I beg to mention, test appeal 1 of 25. It was last listed on 4/9/25. On that day, the respondent council took an adjournment without informing us. We have some urgency. Let it be fixed on 22.
On 22.
Lordship.
At the stage, at what stage?
It is on admission stage. Last listed, it was on orders.
It was for order.
Orders.
You see, the notification has been separated, so we can fix on fix my admission matter. We can fix it only after presentation.
Lordship, then on 14th.
Yes, on 14.
Wait, please, your lordship. Lordship, do you consent of other side? I beg to mention item number 17, your lordship. Adjourn for the day.
17,
17.
1 second. My lord, I am for the respondent, my
Okay,
lord.
Learned Counsel Mr.
A.K. Kanu,
A.K. Kanu, on behalf of Learned.
M. Ahmad,
Huh?
M. Ahmad.
On behalf of Learned Counsel Mr. M. Ahmed has prayed for adjournment. Learned Counsel Mr.
S.R. Borguya,
H.R. Borguia.
S.R. Borguya.
S.R. Borguia
Mm.
is present for respondent number 1.
Yes,
List the matter
My-
after puja vacation.
date may be fixed, my lord, because we have filed an idea for early hearing, my lord, date may be
20 November.
20.
2020.
May I please, your lordship? Lordship, with due consent of other side, I beg to mention item number 18 and 19. It may be listed after vacation on 23rd if possible, because there is some urgency.
Learned Counsel Miss
V. Rai.
V.
V.
We write on behalf of learned counsel, Mr.
SP Roy.
SP, Ray, with the consent of the other side as paid, judgment list the matter will be on,
23rd of October.
not on 23rd of October. 18 November.
Lordship, there is some urgency in the contempt application. They have been proceeding with the construction over the suit land. There is interim also in item number 18. Interim
They
is
order Mr. limiting postal, then
much of it.
May I please, your lordship, I beg to mention for listing of a RSA next week, my lord, for orders. Because we have filed three,
no, see, I'm really very sorry because by order of Chief Justice, a notification has been circulated to list only motion matters on the next week. So we'll take it up after vacation, immediately after vacation.
lordship.
You want a date?
After, the date may be fixed after vacation. 6 oblige.
Wait, please, your lordship, mine is the same player lordship, for listing of a CRB, but here's urgency is lordship, the execution is going to be held lordship. Can it be before vacation lordship?
Then I just said about the circulation.
Yes, lordship, I understand lordship.
Execution, when is the next date fixed for execution?
And probably lordship, on first week of October lordship,
First week of October.
probably lordship. Oblige lordship. But lordship, another prayer lordship, listing of a MSC appeal after vacation lordship, any date. Oblige lordship.
May I please, your lordship? Lordship, I beg to mention item number 12. But that will be adjourned for the day. Item number 12.
Learned counsel, Mr. B Das.
B Chandra.
B Chandra has prayed for, with the consent of the other side, has prayed for adjournment, list the matter after puja vacation.
May I please, your lordship? With the consent of the other side, your lordship, I beg to mention item number 11. Consent has been taken, your lordship. I'm for
Learned counsel, Miss
Ms. K. Sharma for respondent number 3, 1, 2, and 3.
K. Sharma on behalf of.
Mr.
Learned counsel, Mr.
GN Sahewala, your lordship.
DN Sahewala for respondent number 3, 1, 3, 2, 3, 3. With the consent of the other side, has prayed for adjournment, list the matter after.
Your lordship, on 16 October, if possible, your lordship.
Wait, please, your lordship.
Positive for hearing decree, as this is an old pending matter.
Lordship, I'm praying for listing of an IA for tomorrow, lordship. That CRP IO matter, lordship, I heard yesterday, lordship. I'm praying for listing of IA for correction of necessary
I relating to what? Let me know.
details, correction of details in respondents' details, my lord. My lord, I fix the matter
Or
tomorrow.
next week.
Much.
Kindly not tomorrow, next. week.
Tomorrow, the CRP matter is fixed, my lord. So
Tomorrow.
along with that, I'm praying for listing. Much obliged.
Lordship, may I pray for listing of a CRP IO, your lordship, immediately after vacation, your lordship. Deeply obliged.
May it please your lordship. For item number 9, I'm appearing for the appellant. I do not seek adjournment, but my understanding the appeal stands abated. I'm in a different court matter. It might continue some long. If in such circumstances, because it's on abatement, lordship will kindly accommodate me for some time if the matter is called.
If you are in a different.
If my colleague may not be able to correct it, please.
Item number
9,
nine, okay.
because appeal has abated, I know that. Because in his presence, I would like to say that, that's why. Yes.
Nine. Item number 1.
May it be please,
This matter may kindly taken after some time, lordship.
Somewhere. Item 3.
SCR has been received.
Yes, we have the LCR, yes. Yes.
My lord, petitioner is behind bars since last 2 years, 3 months, 15 days. In connection with this case, and 2 other co-accused have been already been released before few months ago. Second, important thing is that the rules of, with regard to rules of arrest has not been adhered by the prosecution while making his arrest. In pursuant to the directions laid down by the Honorable Supreme Court in Bihan Kumar and other cases. So, my lord, my limited prayer before your lordship, which your lordship will find at paragraph 12 and 14 of this bail application. Annexa 3 may kindly be perused.
Annexure,
3, page 22. Operative portion,
page 20.
operative portion 23 page.
Okay. Yes.
In this case, your lordship,
Okay.
the prime accused, one Jiaul Haq was arrested in connection with this case, and subsequently he has been released on bail, considering the judgment of the Honorable Apex Court passed in Bihan Kumar and so and so. In the same case also, prosecution raised objection regarding the possession of the contraband in respect of the said accused person, but that has been rejected, and considering the constitutional mandate of Bihan Kumar's case, he was granted bail, which was passed by this honorable court on 10/8/5/25. So though parity is not a good ground in the criminal cases on facts, but my case is the parity on law. Because by adopting the same ratio, prime accused person has been granted bail. So by adopting the same ratio, I am entitled for the same relief, my lord. That is my limited prayer. Except that, my lord, if your lordship would go to the record of proceeding, since 14 February 25, there are 10 prosecution witnesses. Since 14 February 25, no prosecution witness has been examined by the learned trial court. Only 3 out of 10, only 3 have been examined, and rest of the period, last 7 months, no PWs are examined in this case. So more particularly should be allowed to go on bail considering his length of detention, as well as the grounds of arrest which was not communicated. And if lordship may kindly peruse page 30, the notice issued page 29 and 30, which is Annexa 6 and 7. There is nothing mentioned about the grounds of arrest. Annexa 6 and 7. There is nothing reflected with regard to grounds of arrest by police while arresting the accused person. So he may be allowed to go on bail by adopting the same ratio which I submitted in Annexa 3, my lord, who is the prime accused. And so far as this person become the victim of foul played by this Jiaul Haq, who friendly requested to go to some local place, come and ride in my bike, and suddenly he was arrested along with these unlawful activities. So nothing directly recovered from this possession. And if your lordship would consider the testimony of PW 1 to 3 in this case, there is nothing incriminating against the present accused person. Nothing whisper about any involvement of the present accused person in the entire case. So, my lord, considering all this aspect and rest, I leave up to your lordship whether prosecution can prove the case beyond reasonable doubt before the learned trial court or not. That is the future course.
I do not know that opium, what type of contraband it is.
This
Is
type
it a
of-
very deadly contraband? Opium,
It is flower, lordship,
Huh?
flower.
opium, flower.
Firstly, I want to state your lordship, they are 3 times rejected. Firstly, and again, if we look into page 35, he has already taken the ground of 47, lordship. It has been rejected by lordship. This is page 35, lordship.
Paragraph 16.
Paragraph 16. It has already been rejected and he has already taken the ground. Moreover, lordship got it. Okay, lordship. Yes, it is discussed. All discussed and rejected. Then lordship, prolonged procrastination. It is also taken, lordship, and it has been rejected. Page 27, lordship. It has been rejected. Out of the 9, 4 has been already examined, and I have seen the record, 5 has already been examined. So it is at the fake end of the trial, lordship. on, now, Lordship, almost half has been done. Half of the witnesses has been done.
Only few.
And it has been taken into account. Again, Lordship, it is 37s come into play. As this is a commercial quantity. 9, Lordship. It is written in the of the rejection order also, Lordship. In page 28.
It is 10 witnesses, my lord, so far as my understanding.
In page 28, Lordship. Para 6. Trial is progressing at a regular pace, 4 out of 9. And 5 have already completed, Lordship. And next date is
Not-
10/9/2025.
I have a copy. Can you point out whether testimony of 5 in LCR?
Yeah, I can.
I have a deposition of
To detail.
only 3 witnesses. When last recorded?
Opium is a flower.
I do not know because
It is in
not
17C, Lordship. It is commercial quantity.
commercial quantity, whatever it may be, but we are not on merit at this stage. Our case is that only I am the co-accused. I was sitting just behind the bike. There is nothing in my
Okay.
hand. It was from the side bike.
It will fine.
When recorded? Recorded when? Correct. 14 February, yes, I am correct. Since 14 February, no.
Whatsoever, I don't talk on blues.
None has been examined.
It has been so all his grounds falls flat, Lordship. He has already taken all the grounds.
No.
It has been already been rejected. He has also taken the ground procrastination. He has also taken the ground 47, and no new ground has been first he has to show no new grounds, Lordship. He has not shown. Earlier grounds were all taken up again and again, Lordship, reiterating.
Then, my lord, I have to submit that. On last occasion, your lordship, observe that the judgments of the Pankaj Bansal and Pankaj Bansal and Kobir Purvasta's prospective effect with regard to the arrest of the accused person. There is nothing observed in respect to the present petition that whether this arrest was legal or illegal. No. I am just like to point out and refresh your lordship's memory
No,
that it
You don't do that.
no, with due respect, my lord. On last occasion, your lordship came to conclusion at my learned friend point out that at para 16.
Don't point it out.
No, no. It is apparent that the decision of the Honorable Supreme Court, Pankaj Bansal and Kobir Purvasta's has prospective effect. So my application was not filed before your lordship to determine that whether the arrest of the accused person is operating in a prospective or retrospective manner. I have filed this application that my arrest was illegal.
Discuss the present application.
Yes.
Forget about the.
Yes. Whether it is legal or illegal in terms of the judgments of the Honorable Apex Court as laid down in these 2 judgments. But this Honorable Court was pleased to determine that it has a prospective effect. That means these judgments are not applicable in this case, in my case. So far as the various judgments of this Honorable Court speaks that these judgments are applicable, there is no retrospective or prospective effect over the arrest because so far as the judgments of the Honorable Apex Court in Koenig Sina, it has been clearly laid down that the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature unless it has been specifically stated in the statute itself about the retrospective operation. The reverse is true for the law which is laid down by a constitutional court or law and it is interpreted by the court. The judgment of the court will always.
This is not required. I'll take the help of another.
This is,
Which I know.
if your lordship
I'll take.
go to determine the retrospective or prospective effect of a judgment of the constitutional court.
Something. I'll take the help of another judgment, which I know, which is State of Karnataka versus Darshan Singh.
But
And I'll decide the case on the basis of.
that has not been relied in the previous judgment.
I'll rely, that's what I'm saying. I'll rely on the judgment.
So far, this is the settled law, man. And Bihan Kumar,
What is settled law about prospective and
Definitely.
retrospective? I'll take the help of another judgment, State of Karnataka versus Darshan Singh. If you want to go through the judgment, you go through it.
because learned people.
I'm assuring you, I'll take the help of that judgment. State of Karnataka versus Darshan Singh. Darshan.
I have not gone through that effect. So far as law is, this is settled, my lord. What in mechanics,
Now you will have to go before the higher authority, as I have made a mistake.
I have a-
Before, Supreme Court maybe.
it is not possible for this type of very lower middle class family to approach Supreme Court in today's era. So that's why I am repeatedly approaching this court. In number of judgments and this court, this coordinate bench, also, it is also settled that a coordinate bench should not come to a different opinion on same subject, it may be referred to a larger bench. That is also so far as my limited understanding on law. So far as my lord, various judgments, your lordship knows that in various courts of our court have unanimously held that, yes, if the grounds of arrest as mentioned in the Article 21 and 22 is violated,
Unfortunately,
then
your
the-
accused have been granted bail on Vihan Kumar, but you are not granted bail on Vihan Kumar.
that is I have pleaded,
Unfortunately.
unfortunately, that is,
Have been granted bail on Vihan Kumar.
yes, Bihan Kumar and Pabir Purvasta, so far as in this case also. So my prayer before your lordship, not on parity on facts, but it is a parity on law. Because both all these three accused persons are facing trial, two are from outside and this is from inside. So that is the
So,
discriminatory
but I do not know,
and similar,
how harmful this opium is, I do not know. How much?
that
is
may
the-
be, we also do not know. We have never seen.
I will consider only that.
So my lord, my application,
Quantity,
yes,
as I do not know the effect of opium.
because
I
there.
consider only.
So far as then your lordship would have considered the merit of the case.
I do not know, see, I don't know what I'll decide. I'll reserve it for order.
Because
Maybe a day after tomorrow I'll pass the order.
and nothing incriminating has been disclosed against the with
I'll
regard to
consider
seizure
Submission on this point.
witness. And so far as earlier rejection order, my lord,
Not supposed to go through the evidence,
yes,
but even then you are saying that he was sitting, he was a pillion rider, maybe he's innocent, I'll consider this submission.
Yes,
Only
yes.
this submission.
yes, yes.
And then I'll just check from somebody, maybe from artificial intelligence also, the effect of opium, I'll just check. And then I'll decide.
That may be, but we are not experienced with this type of contempt. These are FSL experts. We have never seen, we just appear before your lordship only on the points of law and facts. Anyway, my lord, considering his length of detention and the parity on law, my application may kindly be considered. Length of obliged.
Assure you.
In case of prisoner.
My lord, I would like to one judgment of this honorable court, if you lordship will kindly consider.
Well, actually,
There are some Supreme Court judgments have been referred in this.
actually, have one whole bunch with me. I have one file, this fat, all the judgments of my coordinate bench and all the judgments of Supreme Court only on anti-clothes.
Lordship, if your lordship cite this judgment in judgment, then we can also understand the actual point of law. There should not be any confusion.
Right, use. I have.
There should not be any confusion. So if this is relied in judgments, then we can also go through. Published.
Do you want to just submit?
Okay.
Like that.
Yeah, please, sir. Okay. Those are anticipated bail application. CV was called for you.
It is available. I have the CD.
So here, Lordship, the other accused persons were all been granted bail, Your Lordship. Due to simple injury or nature isn't reflected in the bail orders. Here, I have come with the wrong identity, Your Lordship. Here, I have not been involved in this matter in the place of, in the date of occurrence and the place of occurrence. I was not being present. I was a pooling agent, Your Lordship. Page 20 is my ID, the pass of the pooling agent. On that particular day, I was on duty under the presiding officer. And at the incident took place at
Page
around
20?
page 20. Page 20 is the pass for the pooling agent, the Sariful Islam. On that particular day, he was a pooling agent in the under the presiding officer in the particular room. He cannot go outside without the prior permission of the presiding officer. And the incident took place at 4:30. Whereas I was there inside the room till 5:30 till the box was being filled. But police has been trying to apprehend me under a wrong identity as a Bablu is named therein in the FIR. His father name tallies with my father name. And that is the reason why I have been apprehending him.
Who?
Sariful Islam.
Another person, who is the other person?
The other person is Bablu.
Father's name is similar to your father's name.
Bablu is the accused person name in the FIR as Bablu. Accused number 11.
Alright.
On that ground, Lordship, I want to clarify these things, Lordship. Yes, it is true that in the FIR, Lordship, serial number 11, it is stated as
And which is-
Bablu.
what is
Bablu.
that?
Lordship. FIR is dated 9/5/2025.
Page.
Page is 19, Lordship.
Okay.
But I have seen the case CD, Lordship. Here in the order sheet, it is clearly stated that Sariful Islam alias Bablu. So it is clear that, Lordship, he is the same person and the identity is the same. Again, on another point I have found, Lordship, in the search list, his name is Sariful Islam Lordship, that is alias Bablu. And I have also communicated with the police person, Lordship, Ayu. He has also stated that he is the same person. So on that count, it has been clarified. Moreover, I have also found that, Lordship, this is a case of rigged election, Lordship. And the police officials, he has also received injury, though it is a simple injury, Lordship. I have the injury report is also there, Lordship. So altercations and fight is there, Lordship. It proved that. Moreover, the witnesses are also there who came to vote, Lordship. They also stated this name person Bablu. Complainant also named Bablu. Other person also named Bablu. So there is clear incriminating materials against him that the present is person, present at that point of time, and it has been named by the witnesses, informant, all of the person named this, Lordship. The only confusion is that whether the Bablu is the same person with the Sariful, Lordship. It is there in the order sheet also, Lordship. It may, Lordship may kindly peruse it. Is Elias.
Lordship, I'm not going to dispute with this, the report that has come forward. It is a matter of trial, it will be proved therein. But based on the materials that is available with the simple injury, all the other accused person has been granted bail. The main accused has been granted bail on the basis of the simple injury, Lordship. So he may be granted the custodial interrogation is not necessary for him. Let him face the trial, Your Lordship.
I have objection, Lordship, because since this is a case of, they are hitting hard at the democracy, Lordship. Because there's a
Rejected order?
Your Lordship, I have given on the last occasion, I have given the number of bail orders that has been granted by this court and
No,
also
your rejected order?
my rejected order, Your Lordship, that page. Which rejected order, Your Lordship, has asked for?
Your bill was earlier rejected?
No, Lordship. My bail was not rejected. The bail is that was granted by to the other accused person in this same FIR that I have provided therein.
in the lower court, it has been rejected, Lordship. I have shown it.
In this court, it has
Bablu,
not been rejected.
in that court, no.
No, one is suffering from ailment. I have granted anticipatory bail, yes. One is suffering from ailment. The others are all BA, not
There is
AB.
another AB passed by the court number 25, where it has been stated that due to simple injury, they have been granted bail. Actual interrogation is not necessary.
This is another bench. I have rejected earlier, and then when he came up for the second time, he came with a,
To do another bench, your lordship, the same FIR, same thing, anticipated bail has been granted, your lordship, due to the simple injury in nature. So here also, lordship, he also deserves to go on bail, your lordship. Let him record his statement before the IO.
I'll check his role.
Yes, sure.
I'll check his role, let me see.
Because lordship, the incident occurred at 4:30. It is not at all possible to be present there in the place of occurrence. He should
No,
be inside.
that I know very well. How he will be present
Now, lordship,
and how he won't be present, that I know very well. I've been residing near polling centers because government quarter, I have been residing near polling centers throughout my life, and I have heard markets all the time in polling centers.
there might be lordship, but at 5:30, he would not have been allowed
I
to
have
go
heard
there.
markets.
Lordship, may kindly go through the expenses.
Yeah, earlier I have rejected all the anticipated bill applications of others, no? I've rejected, and then after new grounds I have granted when they are sick, not well. So why should I grant you now?
Now, lordship, another, in this,
Bench, but you see, I am functioning in a different manner. Other anticipated bills are rejected. I have done a bail after,
Yes, sir.
when they were in jail, after they were arrested, they were brought into custody, then I have granted bail. But now,
no, lordship, it will be unfair for him because other persons are, it's not the same accused persons, main accused person has been.
bars, no?
No, he's not behind bar, but he might be taken into bar. He might be given opportunity to just record his statement, your lordship. There is a given by him. The report has been given by the IO. Let him, the interim may be given to him. That till then the up-to-date CD may be called for. If not,
Lordship, this
then
is
he
a
may be
serious
given an
matter,
opportunity to
Lordship,
record his
and
statement.
he is on anticipatory bail, Lordship. Firstly, it is there, it is anticipatory bail, not a bail application, Lordship. Moreover, this is serious. He has fight with a working Lordship on duty.
That is an allegation, your lordship.
Governments are public servant on duty. He has Lordship.
Now
this
he
kind-
kindly
do
say that
this
he
kind
was
of things,
inside the
Lordship.
polling booth. He is saying that I am in the place of incident. I may be given an opportunity to record. my
Other persons
statement
also
before
named
the
him,
IO,
Lordship, not this thing only that the only complainant, one independent witness, Lordship. One of the witness who came there to vote, Lordship. He has stated this person.
There are case laws, your lordship, where it says that the main accused person has been granted bail, the other accused person may also be granted bail. And here also,
give me the case law.
yes, I will provide, your lordship. I,
Have we preferred the bail before the sessions court?
Lordship,
Have you preferred bail application before sessions court?
Lordship, that I do not have the knowledge about it. They have approached me, I have filed for this.
No,
court,
they have
Lordship. It
approached.
is-
The order sheet, Lordship.
Sessions court?
No, the session.
What are the offences under which he is booked?
Under section 189, Your Lordship, unlawful assembly, Your Lordship. The 189(2), 117(2), it is voluntary causing grievous hurt. 121(2), it is voluntary causing hurt to public servant on duty. That is 3022, this extortion. 61(2) is the criminal conspiracy, and 109 is attempt to murder, and 174 undue influence, Your Lordship, for at the election. And 351(2), the criminal intimidation. But I have not been named in the FIR, no specific allegation is there against me.
Since Lordship 61(2) is there, criminal conspiracy, we need not to do the everything, Lordship. Mere presence is sufficient, Lordship.
See, once your earlier anticipated bail has been rejected, you must come up with new grounds.
That might be in the district judge court, Your Lordship. It has not
No,
been.
Different person, you cannot come up with different ground, fresh grounds. You must come up with new grounds.
We have taken new grounds in this case.
What
Yeah.
kind of new ground?
He was in the election center, he was a polling agent. This is a new ground. Then these things, Your Lordship, that his name tallies with the Bablu. That we have identified later on.
He should, when he was in the learned law court, Lordship, he should clarify in the court, that court, Lordship, why they have stated alias Bablu. He has not stated anything, that his name is not Bablu.
No, that's not a new ground.
No, Chief, that cannot be a new ground.
The polling,
Person.
No, Chief.
the polling agent, Your Lordship, we have not, may not be taken there in Your Lordship. Even if Your Lordship, the grounds tallies with the district judge court also, Your Lordship, if we are agreed by the same order, we can come before the High Court, Your Lordship, with the same grounds.
First of all, you didn't know whether he.
Yes, frankly, I do not have the idea whether they have applied
Then
there.
you must have-
Now, Lordship, the thing is that if we are agreed by the order of the district judge court also, we can come before this court with the same grounds also.
Now, of course, new judgment, first we have to approach district judge for bail, anticipatory bail.
But,
Only then High Court can take up anticipatory bail application.
but that is the new given by, we have filed this application in the month of June, Your Lordship.
But this was not new. This was always there. The old judgment was quoted. And old Supreme Court judgment.
Same was not being followed, your lordship. That is, no, June month we have done it.
Which I keep on, which I have kept on repeating for so many times. You must approach the district judge and then you come here.
Considering the bail that has been granted to the other accused person, that the AB also, your lordship, by the same pertinent bench, your lordship, he may be given the same opportunity to record his statement. My humble submission before this court. And lordship, moreover, I will give the citations that is been given. The main accused person has been granted bail, the other accused person may also be granted bail. I have the case laws.
When will you give it?
I will give within 10 minutes.
But on what grounds the other persons have been grounded also need to be taken into account. Lordship. Some of them have been
Citation.
medical grounds.
Yes.
Take
Lordship.
it up tomorrow, because he'll have to go through them.
Tomorrow.
The citations will take it up tomorrow.
Tomorrow I will not be available, your lordship. I will provide the same, your lordship may go through
You can keep the CD for next week also.
on Monday.
On Tuesday.
Tuesday.
Okay.
What is your name?
Sabrish Ahmed, S. Ahmed,
S.
Ahmed.
Ahmed, heard learning counsel Mr. S. Ahmed for the petitioner and Mr. K.K. Das for the respondent. The lawyer counsel for the petitioner has submitted for adjournment. This the matter on Tuesday, CD to be retained till Tuesday. Heard na like learning counsel Mr. S. Ahmed is prayed for adjournment and
Okay.
I can file for orders.
Oh, sorry, file.
Well, I am applying for the respondents. I seek some time for filing reply. This is section 5 application, madam. So let it come after vacation, we will file the reply. madam.
objection.
Objection.
How many days?
723 days.
Okay, all right. Heard learned counsel Mr.
A Burua.
Heard na like learned counsel Mr. A. Bora is present for the appeal and learned.
A Das.
Mr.
A Das.
A does is present for the respondent and has some break for time to file objection against this application. 2879.
Obliged.
List
I
of
pay-
vacation.
I pray for a fixed date, Lordship. After vacation, any date, Lordship. No, let it be after Diwali, my lord. After Diwali. Last of the. Let it be on 29th, my lord. 29th of. Possibly.
Item 6.
Yes,
My pleasure, Lordship.
yes.
My lord, here in this case, my lord, kindly see the office note, my lord. Notice on respondent number 1 refused to accept. So it is served. Then 3 received. And 2 with respect to 2, 1, 2 and 3 are residing in the same roof. They are the brother. 2 and 3 is the brother and 1 is the mother.
AD card has been received after service in respect of respondent number 3.
Take.
Answer of notice has been received from respondent number 2 issued by okay, they are residing in the same house.
Same house, same brothers, own brothers, and 1 is mother. 1 is mother. Mother and 2 sons. And here in this case, my lord,
This I 332 33
332
3322 for what?
for injunction, my lord. Here in this case, my lord, the suit filed by the plaintiff initially decreed, my lord. Then appellate court it reversed.
Where is notice on respondent number 1?
A report is there, my lord.
Okay. So we see. No, but.
Actually, they are avoiding the service, man. They are avoiding. In the appeal also same thing. They are avoiding. Why they are avoiding, my lord? Initially, the plaintiff filed the suit, that is the appellant. Suit was decreed.
No,
And
but registered post with AD, what about the registered post with AD?
AD, that is AD. Respect, yes.
Let 1 month go,
My lord,
let 1 month go, I'll pass an order for deemed service. After 1 month, AD is returned, it is returned,
Right.
so I'll pass an order for deemed service.
Yeah.
That respondent number 1 is deemed to be served. He has refused.
already, yes.
And then respondent number 3 has received the notice.
So it is served.
Sir, okay, only respondent number 2, I'll
Two.
pass an order for deemed service. Respondent number 2. After 1 month, it has to be 1 month at least.
After receipt of the, after receipt of, return 1 month.
No, not returned, not required to be returned. 95, 595.
Yes.
AD card is not
It-
required.
It is office note only, my lord.
Not
And
required.
from the
We
date
can-
of issuance of the notice, 1 month.
No, we can, after 1 month, we can pass an order for deemed service.
Yes.
Even if he refuses or whatever it is, we can pass an order for deemed service. If it's AD, easily we can pass an order. It's only 15/9, so it's difficult now.
Prior to that also several notice was issued. Only, my lord,
By-
only some protection is given. Only some protection is given.
Immediately after puja vacation. Because after 1 month, we can easily pass an order for order 5, rule 95.
Yes.
We can pass an order because this is registered post with AD, so no harm in passing an order. If you can give the receipt of that AD also, that will be even better. That notice has been received and 1 month has elapsed or something like that. If you can give the receipt.
No, receipt is, because in the High Court, my lord, registry is taking step.
Registry is-
We are
No,
taking
but,
steps and
this-
registry
this
is
does
issuing.
suffice.
Yes.
It's easy, very apparent that 1 month has elapsed. 1 month will elapse on 15, it is very apparent, so we can pass an order for deemed service. Now, Grand Council Mr. S.K. Ghose is present for the applicant. Have been served to respondent number 3. It is submitted by the respondent number 2 is respondent number 3's mother.
Respondent number 2 is the brother of respondent number 3
Or respondent number 2 is brother of respondent number 3.
and son of respondent number 1.
And son of respondent number 1, who stopped. Respondent number 1 has refused to accept notice. Notice is deemed, as per office note dated 3/1/2025, respondent number 1, as respondent number 1 has refused to accept notice is deemed to be served on respondent number 1. List this matter on very puja 17th, on 17th.
7th. No, some urgency is there, my lord, because
Early, 13 on 13.
13.
Yes. We'll pass an order. After passing an order for deemed service, we'll pass an order.
my lord, in the main case also,
Communicate also.
yes.
Mr. Learned Counsel, Mr. S.K. Ghose is present for the appellant. Respondent, notice, office note dated 17/6/2025, RSA to indicates that respondent number 1 has refused to accept notice. Thereby, notice is deemed to be served on respondent number 1. Respondent number 2 has received notice.
Here in the main case, he has received notice.
Receive notices. Playing not.
Playing.
So it's always better to send notice through a registered post with AD.
All, we have,
Yeah, then
Oh,
we
here
we
also.
can pass an order for deemed service.
Yes.
After 1 month. Note, service report on respondent number 3 is awaited. You can issue fresh notice if you want, you can issue.
no, it has already been received in IA also. 3 has received in IA and here 2 is received.
Okay. Okay,
So,
will appear. Next day they will appear.
and the main case may be fixed for hearing after. Supreme Court.
Main case may fix for you.
Mhm. Then they will appear automatically.
Already admitted. But then if you come up for orders only, because IA is pending.
IA will come up for orders, my lord. And main case, order may be passed for fixed hearing.
No, no. We fix it for orders only.
Much.
Is this matter on 1310?
Much.
Yes. Orders are also not. এটা তো কোসে applicant is not represented. I 21301. Applicant is not represented. Office note dated 79/2025 indicates that notices issued to respondent number 1 has been refused by cabinet owing to insufficient address due to insufficient address. Notice issued to respondent number 3 is returned without service with the comment no such person in the address return to sender within inverted commas no such person. আৰু আগতো refuse by cabinet CR লিখি দিব within inverted commas লিখি দিব refuse by cabinet CR due to insufficient address যে আছিলে এটো inverted commas লিখি দিব service reported respondent number 2 is submitted. Is this matter up to presentation? Meanwhile, you can go to a fresh step to be taken out to notice to respondent number 1 and 2.
May it be pleases your lordship. Your lordship, on the last occasion also, he is taking time, your lordship. Now, your lordship, I would like to start it, your lordship.
But what about the other side? He will come finally.
Your lordship, I don't know that his junior is there, but he has time for mentioning, but he has no time for appearing in this
Where is
matter.
the junior?
He is not available here.
Let us wait for some time. You have some urgent work?
No, your lordship, I'm just here for this matter only, your lordship, because on the 2 dates, your lordship, last occasion, your lordship, he took time again and again. So, your lordship, this
When
is,
he won't turn up, then we will take it up.
yes, your lordship, I'll
After
be
two,
there.
Immediately after 2, we'll take it up if he doesn't turn up.
Yes, your lordship.
Or if you
Or
want
your lordship, before 1, your lordship.
before 1.
Yes, your lordship. It won't take much time, your lordship.
I understand it's unlikely that he will come before 1, but we'll take up.
Yes, your lordship, I'm deeply obliged.
Your lordship, I am for the applicant. I couldn't go through thoroughly the brief of the case, your lordship. Yesterday itself, I got hold of the brief. It was earlier, it was misplaced due to changing of the number, your lordship. I immediately. Your lordship.
But actually, there is nothing to
argue, my lord, because the decree has already been executed long back, my lord. That decree was executed in the year 2009 itself. Because they are possessing certain portion of the land, I am possessing. And I purchased 10 lakhs of land. And in 10 lakhs of land, my lord, there are some encroachment, etc. Now I am in possession of 8 lakhs of land. And decree has been executed for the entire land. Later on, my lord, they have partitioned the land.
And then you, is there any stay in this case?
Some portion is in their possession, some portion is in my possession, my lord.
There is an injunction, your lordship.
Injunction.
So that has to be seen. It is a second appeal, your lordship. I've only got the.
This is the my lord order.
You'll get an opportunity to be heard. It was a long pending, it is a second appeal since 2010 it has been filed. So due to the misplace of the record, I couldn't go through it. So immediately after vacations, I have.
No, my lord.
So where the degree is liable to be set aside, I will satisfy the code, your lordship.
You will also let the matter be
Your
fixed on.
lordship, if you go through the documents and the exhibit itself, they don't have a title. From their bare reading of the documents, it seems that they don't have a title. Only on the basis of an unregistered sale deed, they are telling that they have a right title.
Decree has been already executed, my lord. If they win also, they cannot come back to possession, my lord.
Your lordship, they have paid a title suit for recovery of possession. We are in possession, your lordship, of that said plot of land.
The matter may be fixed on 23rd, my lord.
23rd.
Because after the vacation, my lord, I will not be here.
After the
23rd, one week time, my lord, they will be.
Your lordship, here are. It is not a hearing date.
23rd, 24th, any day.
Not a hearing date, your lordship.
No.
Hearing date is. Hearing date, we have fixed so many hearings. 23rd, we have many cases.
The vacation, your lordship. It is.
No.
It will take time, your lordship.
No. 23rd is the hearing date, my lord.
It will.
30th October.
Yes.
My lord, after Puja vacation, my lord, I will not be here, my lord. That is the problem, my lord. Let it be fixed before vacation any day.
You will come back, no, after Puja vacation?
Actually, I shall be out for 2 months. That is the problem. It is a old pending case, my lord. 2010 case. I want to dispose of it, my lord.
You'll be here on 23rd.
Yes, 23rd, 24th, 25th, any day, my lord, according to their convenience.
24th, Friday did you get hearing on? October. Okay, you are asking for September?
Yes.
Oh, no, we cannot fix on September.
Before
We
vacation,
cannot fix on September. September's are motion dates.
almost Sunday, my lord.
Yes, all, and that notice has been circulated by order of Chief Justice. So we cannot fix for hearing.
Then I will have to take adjournment, my lord. That there is no other alternative.
When will you be back? After 2 months?
At least 2 months, my lord. It will take.
On November date, November on 11 November. 11 November, will you be back on 11 November?
No, my lord. I will take adjournment, my lord. You will also may be pleased to hear. Because this is a old pending case, my lord. That's why I want to.
Yes. 18 November?
You will also may fix it. I cannot say anything.
From today, 18 November. Or maybe 18, 19, 20 November?
Yes.
Learned Counsel, Mr. P. Chaudhary is present for the appellant and has prayed for adjournment as he has lost the brief.
Earlier it was misplaced, your lordship.
The brief was misplaced. Full stop. Learned Counsel, Mr.
PK Kolita, my lord.
P.
PK Kolita.
PK Kolita has raised serious objections. Stating that this is an old pending case. However, for interest of justice, the last opportunity is accorded as this is an old pending case. List this matter positively for hearing on 20 November. That's it.
deeply aware.
Item number 8. Item 8.
So also the other council, we were trying to contact him since last night, but we are not able to reach him.
Miss
K. Sharma on behalf of Mr. G. N. Sahewal.
Learned Council, Miss K. Sharma, on behalf of Learned Senior Council, Mr. G. N. Sahela is present. And this matter has been listed for the first time after 1970 for interest of judges. This matter for reading positively on the 18 November, without fail. Without fail, positively for hearing on 18 November, failing which, necessary orders may be passed.
Item 9.
Well, I've requested my friend for the brief minute. So far as this case is concerned, the appeal stands abated. I presume there's some debt under.
No, appeal stands abated on the demise of the appellant number 2.
Both sides.
Yes. Appellant number 2, they have not filed any application for substitution, so it is stands abated. And the appellant number 1
One-
is not intending to pursue this appeal any further. So at
Will
this
be
stage,
closed,
it may
will
be
be closed.
dismissed on abatement.
It can be closed, Miller.
Can be closed.
Yes.
Can close.
Legal aids are also not willing to continue.
So far as 1 is concerned, they're not willing to continue. So far as 2 is concerned, although we had interaction, but they are not approaching to file therefore. That's the state position we have put in Miller. Lordship indicate that the appeal stands abated. That would do. Even if they take subsequent steps, they can do that.
Exactly. They can file.
It would preserve both sides without. If they want to file through other council,
Yes, that will.
that will be better. Only that.
Closed on abatement.
On abatement.
On abatement. Because the option will remain open.
Yes.
Yes. Close release now.
Very old case.
Yes, old pending.
Very
matter,
old.
Lordship.
And written judgment.
Yes, and written judgments. Even the type copy is not there.
I also used to write
Mm.
written judgments.
This lady ultimately not intending to pursue this matter because of the delay. The appellant number 1. 2011 matter, Lordship, now it is 2025. For last 14 years, this matter is pending here.
Brother, sister.
Yes, to some extent, the dispute is within the family.
Learned Council, Mr. S. Boni, is present for the appellants and.
SP Chaudhary, Lordship.
And Mr. S. P. Chaudhary is present for the respondents. The appellant number 1.
2 has died.
Appellant number 2.
2.
Appellant number 2 has passed away, and thus this case is closed on abatement of,
On a,
as this case has been abated against appellant number 2.
No, Lordship, the appellant number 1 is not intending to pursue.
One is also not intending to pursue the matter.
So then we will close it there.
Yeah, exactly. Exactly, Lordship.
Appellant number 1 or 2 passed
The
away.
2 on abatement, 1 will
And
not
passed away.
continue.
Therefore, this case against appellant number 2 is abated.
Wow.
The appellant number 1 is not willing to.
Pursue this appeal.
This appeal and has prayed for withdrawal.
Not
Exactly.
withdrawn. Let the matter be closed.
Is pursue this appeal. Is not willing to pursue this appeal, thereby this appeal remains closed.
Yes. And the stay order which was there, Lordship, in the last
Where?
occasion.
You know,
There should be orders in a miscase. 41.5 should be there.
here in this appeal, there is no stay order.
If there's orders in the miscases, that should be vacated.
One is that it stayed until disposal of.
Exactly, Lordship.
Okay.
Miscase litigation.
No, it continues only till today only. It
No, no.
goes.
Yes, Miss case, yes.
The order
Yes, go ahead.
pay in connection with NC 159, 2011 remains vacated.
Yes, obliged lordship.
Send back the.
LCR lordship.
Trial, send back the trial court record as well as the original appellate court records.
Lordship.
Send back the original trial court record as well as the original appellate court records.
Obliged lordship.
Item K.
Very clear, Lordship. My lord, I am the defendant appellant in this matter.
2015.
Yes, sir. My lord,
Started last my news.
ওপৰত বহুতে টাইপ কৰা আছে দেই RA 195 2025 2015 কৰি দিব লাগিব হোৱাইটিং মাৰি পেলাই ইয়াত এইটো হোৱাইটিং মাৰিলে হ'ব নে কি কৰিলে ভাল হ'ব এইটো ওপৰত ভুলকে টাইপ কৰা আছে অৰ্ডাৰটো চেঞ্জ নকৰিলে ভাল হ'ব হোৱাইটিং মাৰি পেলাই ওপৰত টাইপ কৰিলে ভাল হ'ব তুমি লিখি থোৱা RSA 195 2015 order dated 28/8/2025 report likha hai 2025 June 2 jagah 1 likhi denge
so my lord, this matter, my lord, pertains to my lord, I am the defendant, appellant, and the plaintiff is the respondent, my lord.
so we will start with the judgment of the appeal court
Yes, my lord.
then we will go to the other then we
Yes.
will understand the story also
Yes, yes,
if we go to the judgment of the appellate
yes, my judgment of the appellate court, my lord. Page number 7 starts. My lord, appellate court, my lord, set aside the judgment of a trial court, my lord.
page number 7
Page number 7, my lord.
you are the defendant
I am the defendant.
then you became the appellant first first
Yes, my
the
lord.
first appellant
Yes, my lord. Page number 7. Page number 8, may I read, my lord, from the second paragraph? The plaintiff's case in brief is that plaintiff purchased a land measuring an area of 1 kata 5.2 gonda from the principal defendant, that is the appellant, my lord, after execution of sale deed 5192 dated 16/10/2004 and registered rectification deed 3/2/2005. But when plaintiff went to visit the said purchased land, he found that one Rafiq Ali, that is defendant number 8, was Rafiq Ali was the pro forma defendant, my lord. 8 was occupying the second scheduled land except third scheduled land as described in the plain. So, my lord, here the plaintiff case is that I have sold him 2 schedules, second and third, and he is in possession of the second scheduled land, and third scheduled land, Rafiq Ali, pro forma defendant 8, dispossessed him, my lord, after my sale. So this is third scheduled land. From said defendant number 8, plaintiff came to know that page number 8. Plaintiff came to know that he had purchased the said land along with other lands from pro forma defendant 5 to 7. That is, from Rafiq Ali, he came to know that Rafiq Ali purchased the land from pro forma defendant 5 to 7. That is, which plot of land I had sold to the plaintiff is subsequently Rafiq Ali, pro forma defendant 8, purchased from pro forma defendant 5 to 7 and dispossessed him by registered deed number so and so. 24/12/2004. It is important, my lord. My sale deed was 16/10/2004. The date is important, my lord.
My sale is prior sale is 16/10/24. And that pro forma dependent number 8 purchased on 24/12/2004. That is his salary is subsequent. So the present position is that plaintiff is now possessing land as described in Schedule 3 of the plaint, although he sold the land of Schedule 2. Thereafter, plaintiff approves the principal defendant to hand over the possession of the vacant land or to make alternative arrangement, but the defendants on this or that ground delayed the same. So when the plaintiff found that pro forma number 8 is in possession, so he come to the appellant defendant to give him an alternate plot of land. This is the case of the my lord plaintiff. A village bichar was also organized by the plaintiff, wherein it was decided that principal defendants shall either deliver the land in question or an amount of 52,000 to the plaintiff, but in spite of that, defendant did not make any action. In the year 2006, another sitting was held under the intervention of well-wishers, and it was resolved that principal defendant shall execute and register a sale deed in respect of Schedule 4 land, measuring 1 kadar 5.2 konda. So this is important, my lord, that I had other land also. But in the case of the plaintiff is that I had no title and I had sold the land of pro forma number 5 and 7. That was the case of plaintiff. But here, my lord, it is mentioned that though it is not admitted in the bichar, it is held that the plaintiff had other land, that is Schedule 4. Defendant has other land, Schedule 4, and which is equal to the land I have sold to the plaintiff. That is 1 kadar 5.2 konda in favor of plaintiff in lieu of earlier sold Schedule 2 land, but defendant did not act upon. So since the plaintiff case is that he was dispossessed by pro forma number 8 from Schedule 2, so I should register him my another plot of land. This is the case of the plaintiff. Now defendant number 1 and defendant number 8, on the other hand, upon receipt of summons appeared and filed their WS, and the suit proceeded ex parte against the remaining defendants. The defendant number 1 and 8 is the person who purchased, my lord, the subsequent sale.
5 to 7.
Yes, from 5 to 7. Contended that there is no cause of action for filing the suit against the answering and all the principal defendants. The suit is not maintainable in the present form, that the suit is barred by limitation, suit is barred for defect of parties, that the suit is barred under provision of a transfer of property, specific relief.
5 minutes.
Obliged.
I'll come after 5
Obliged.
minutes.
Inherited the entire FAT schedule land from his father, and pro forma defendants have no right title over the same. He sold land measuring 1 kadar 5.2 gonda. 5 pon is about 1 katha, my lord, and 1 kadar is 1 biga 4 katha. So it will be about 1 biga 5 katha. In favor of plaintiff out of his total land, and also handed over.
I'll just be gone.
Obliged.
It was very important. I keep
Yes.
forgetting. 1 kadar
1
is
kadar is 24 katha in Barak Valley.
katha.
1 biga 4 katha. And 5 pon is a local measurement. It is about 1 katha. About 1 katha. So it will be 1 biga 5 katha 2 gonda. Out of his total land, and also handed over possession. This handing over of possession is, I will come to the exhibit sale deed. It is also mentioned that a possession is handed over, and he also admitted, the plaintiff, that possession is handed over, and after few months he came to from this Karimganj district to Dimapur. He is a resident of Dimapur. He, after purchasing and taking over possession, he went to Dimapur, and after a few months he came and found that pro forma number 8 in possession.
pro forma dependent,
Eight.
but it was in possession.
in possession. So this is the scheme. So according to him, the suit has been instituted by the plaintiff in collusion with pro forma defendant to grab his property and as such prayed for dismissal of the suit. Defendant number 8 in his WS stated that he purchased the land described in Schedule 2 and Schedule 3 of the plaint from pro forma defendants by registered deed number so and so. My lord, my friend appeared for pro forma number 8. The plaintiff is not appeared, my lord, in this second appeal. In the last occasion, your lordship has last order mentioned that service is complete, but he did not appear before this court.
Plaintiff did not appear.
Did not appear. My friend for pro forma number 8.
Okay.
I'm for 8, my lord.
Last order.
Last order is there, your lordship. I think after going to the record, found that service is complete.
Okay. So he's the one who has suffered loss, but he has not appeared.
Yes, sir.
My lord, lordship find some different things after some, my lord, after some paragraph, my lord.
May continue, my lord.
He may continue.
Something different.
Something different, my lord.
Okay.
So, my lord, the defendant number 8 in his WS stated that he purchased the land described in Schedules 2 and Schedule 3 of the plaint from pro forma defendant by exhibit by deed number so and so 24/12/24.
Just let me check the service report once more. As I'm hearing, proceeding for hearing.
Yes, my lord, last order, I think.
That is my order.
Yes, your
My
lord.
very own order.
After going.
So I'll just check the office notes.
Yes,
once
in
more.
the last occasion, your lordship, after going to all the records, this order was.
Yes, I said nothing. Check this.
Yes, on the last occasion, your lordship. Check the.
You have a respondent number?
Yes, dear, my lord, I am respondent number.
Plenty will be respondent.
My lord,
number
I am defendant number 8, but in this case, I am respondent number 7.
Okay. So AD respondent number 2, AD card signed by has been received. It's number 2A. Respondent number 1, 2B, 2, 4, 6 have been received. Okay. Itu bagus. Jadi APA pengen respondent number is start out. The one Kedra C लिखा है D लिखा है 3 4 1 A 2 3 4 no 1 U 2B 2 C 3 4 3 4 5 6 6 3 it was 9 stuff Sub-register coordinates. Respond number 8, I'll just check notice have been served or not. Respond number 8, sub-register coordinates.
Oh, it is struck off.
No, 8 is not struck off, 9 is struck off.
9 is struck off.
State of Assam.
Yes. But state of Assam as per order 15/12/15, my lord. 15/12/15.
Or 15, 12, 15.
15/12/15.
8 has been struck off.
No, my lord, complete, my lord. 8 complete. 15/12/15, my lord, I
15,
think.
12, 15.
15/12/15.
Okay.
15/12/15. I think so. Office note, my lord, it will be office note. 15/12/15.
Office note dated 15, 12, 15.
Yes, my lord.
No.
Yes, sir, Condor case.
From 1 to 8, my lord, complete is mentioned.
Such an old case.
Yes, my lord.
Yes, yes.
Yes, my lord. 15.
346, 80 cards returned for respond number. Answer notice.
Subsequent order of the Lozima Court, my lord, 27/9/16.
27/9/16.
9/16, yes, sir. Lozima Court.
He's not an important respondent, but even then, 27/9/16, no?
27/9/16.
Yes.
Since there is no prayer of my lord, cancellation of sale deed, so sub-register is not,
I know, but just I'll check.
yes. 15/12 mentioned by the complete, my lord. And
What do they mean by noting down 80 cards returned from respondents so and so? Whether returned after service, they must write down. And then this court has passed an order also.
yes, sir.
To bring to the notice of register administration, why they are passing the office. Even 4/4/16 also, service returned. But whether served or not, they have not mentioned. And then this court passed an order on 19/6/2017. Strict order was passed on 19/6/2017. They must clarify whether it is returned after service or not. Check paper sunday respondent number 8 too. Maybe. What is his name? Respondent number 8.
8 is the sub-register.
Sub-register, no name is not given.
Sub-register. Sub-register,
Only sub-register.
no, name not required, designation.
Sabason dito? Yat nice. Supplementary file to take on is it? Service of notice, yat nine. But we can consider as deemed service
Yes,
because it was served to postal.
yes, yes, ma'am. We can proceed, my lord. And my lord, they have not filed any WS ex parte against them, so maybe strike off, my lord, if not constituted. They have not contested that case.
কিবা লিখিছে মই বুজি পোৱা নাই Okay, we can continue.
Yes, ma'am.
If you do not want to, if you have no objection, we can continue.
Yes, ma'am.
Yes, respondent number 8.
Yes, madam. Okay. This number 9, my lord. They continue. no? The last paragraph, the defendant number 8 in his
Page
W
number 9.
9, madam. The defendant number 8 in his WS stated that he purchased the land described in schedule 2 and 3 of the plain from proforma defendants by registered deed number so and so, and neither the plaintiff nor the principal defendants have any right title.
Okay, look at them.
Right title or possession, page number 10.
Okay, yes.
Well, may I continue?
Yes.
Well, at page number 10 is the issue. Upon pleadings, the party following issues.
Awesome. Pilot pin my to the 100.
So, my lord, first issue is whether cause of action is there.
Billable asset attention.
Yes, yes.
Page number 10, my lord. One is the cause of action to maintainability, my lord. 3, bearer defective parties. 4 is the whether plaintiff entitled to the decree as prayed for. 5 is whether plaintiff is entitled to get recovery of first possession of second schedule land except third schedule land from the pro forma defendant number 8. It is very important issue. Through the principal defendants by virtue of purchase of second schedule land from the principal defendants.
So this is according to you the main issue.
Main issue, but my lord, this
Issue
issue,
number 5.
issue number 5, this is, my lord, this prayer is not against the defendant number 8. And accordingly, the substantial question of law was framed that one of the question of law that without any prayer against the defendant number 8, whether he can get back the land from the possession of the defendant. That was one of the subsection of law. So here, this issue is very important, my lord, whether he can get the physical first possession of the second schedule land. Number 6, whether plaintiff is entitled to get the fourth schedule land from the principal defendant as an alternative relief. This is also important. The fourth schedule land, the learned trial court had directed to execute register deed on fourth schedule land. Learned trial court held that the defendant should execute a register deed on fourth schedule land. So this issue is also important. The appellate court held that it is order is not a valid order of the trial court granting the decree for execution of the fourth schedule land. So I will continue. Plaintiff examined 4 witnesses and exhibited certain documents. On the other hand, defendants examined 2 witnesses and exhibited a number of documents. Learned Munsif passed the impugned judgment after hearing oral argument of both the sides and considering the evidence adduced by them, being agreed so and so. Point number paragraph 9. Point from the materials available on record, the real question in controversy appeared to be whether the principal defendants sold the suite land to the plaintiff by misrepresentation of fact. So the appellate court,
Very important matter.
very important matter. Appellate court, my lord, decided the appeal on a separate, my lord, issue.
Separate issue.
Separate, this is a separate issue, my lord. Whether there was a fraud, misrepresentation of fact, or TP Act section 55(1)(a) is applied. So decision and reasons thereof. Before pondering the evidence available on record, as regards above point, let us first draw the attention of section 55(1)(a) of the Transfer of Property Act,
Yes.
TP Act.
Yes, you can continue.
Yes, ma'am. Madam, should we go to the provision first, ma'am?
No.
No, good point.
You can continue.
The relevant, it is mentioned here, the relevant section categorically states that the seller is bound to disclose any material defect in the property or in the seller's title thereto, of which the seller is and the buyer is not aware, and which the buyer could not do with ordinary care and discovered. So this is the finding of the appellate court that the by violation section 55(1)(a), the land is sold, but it is not in the judgment that how whether the defendant had no title, how he came, how the learned appellate court came to the, how the learned appellate court came to the conclusion that appellate has no title over the land sold. It is not based on the evidence. I will go through the evidence. It is not a correct finding, my lord, that the defendant, my lord, did not disclose the material defect of the property. And the learned appellate court only on this provision decided that. Now, my lord, further it is pertinent to mention that a contract for sale of land is not a contract uberima fidel, but although the duty to disclose is not absolute, the seller is under an obligation to disclose latent defects of which he is aware. This is the same rule as the Sale of Goods Act under section 16 of the Indian Sales of Goods Act. The defect in titles are always latent defect. For a seller's title is a matter exclusively within his own knowledge and is bound to state it explicitly and to tell the truth and all the truth which is relevant to the matter in hand. And if seller did not disclose the material defect in his title, then such a non-disclosure would be a misrepresentation under section 18(2) of the Indian Contract Act and render the contract voidable. And it is settled position of law that if the buyer discovered material defect which has not been disclosed to him before he has accepted conveyance, then he may rescind the contract for misrepresentation or resist the suit for specific performance, or he may claim damages. So, my lord, these paragraphs are important, my lord. The Lord Appellate Court held that the relief is on specific relief at other relief. The relief sought for is not the proper relief. On the other hand, if the buyer discovered material defects in the property after he accepted the conveyance, he may hold seller responsible in damages and claim damage or claim return of purchase money if he dispossessed by the reason of defect in the title, or may sue to set aside the same. So these are not the prayer of the, my lord, I will go to the plain. These are the not prayer of the
He went to a different
plaintiff.
direction.
Yes, my lord. He want my different land to be.
Appellate court went in a different direction.
Yes, my lord. And the prayer is different. The appellate court held that the prayer is different. Further, the Honorable Justice So-and-so, after reviewing both the English and Indian authorities on subject, stated that remedies after completion of conveyance are much more limited than those before completion because most contractual rights merge in conveyance. His lordship held, if the contract has been completed by execution of sale deed, then the purchaser can claim compensation if he establishes fraud or if there is a special agreement for making compensation for errors in quantity or if there is warranty that the extent of conveyed by the sale deed is correct. In this case, while the contract is complete, the execution, sale deed executed and the possession is handed over. So he has different claim as per appellate court judgment. Now let us come to the point of determination in hand. As regards above point, the plaintiff stated that principal defendant sold to him land measuring 1 Kadar 5.2 Gonda within the area of a plot number 1, first schedule land, that is land described in second schedule of the plaint, and other land by registered deed number so and rectification number so from the share of land belong to Rahman Ali. Rahman Ali is Rahman Ali, it is Rahman Ali, my lord. It is admittedly the stepbrother of defendant's father. That is uncle of the defendant. And Rahman Ali's legal heirs sold to the pro forma department number 8. So predecessor of pro forma number 5 to 7 is the Rahman Ali, who got the same as his share after amicable partition with his brother late Ismail Ali. So it is plaintiff's case that the ancestral property is partitioned between the brothers. It is the appellant's father and his uncle.
Ismail Ali is Appellant's father.
Appellant's father, Ismail Ali. Ismail Ali is the appellant's father, and Rahman Ali is the stepbrother. But there is no evidence that, my lord, the land was partitioned into ancestral property. There is no evidence, my lord. Not a single piece of evidence that it is just ancestral property. There is no evidence, my lord. Predecessor of principal defendants, plaintiff also stated that principal defendants are, after death of late Ismail Ali, inherited only 0.095 acre of land. It is not also, my lord, supported by evidence. This, my lord, predecessor of principal defendant, plaintiff also stated that principal defendants after death of late Ismail Ali inherited only 0.095 acre land, which left out after sale of remaining portion of his share to Horendra Chandra Pal. Horendra Chandra Pal was the Jamindar, my lord, and they are the tenants. My appellant's father was a tenant under Horendra Pal, and they hold the Khatian, my lord, Khatian holders. So the case of the appellant is that it is not an inherited property, and his father himself was the one of the Juddar of Horendra Chandra Pal. That was the case of the appellant. By registered sale, original, my lord, yes, oh, landlord, yes, Jamindar, landlord.
And they were, the brothers were?
My lord, the appellant's case is that only his father was a, my lord, Juddar of the, my lord, Horendra Chandra Pal is a tenant of the Horendra Chandra Pal. Only his father, not his uncle.
Brother.
Uncle was not. This was the case of the, my lord, appellant. Registered his share late Horendra Chandra Pal by registered sale deed number 19465, and who later on sold. So case of the plaintiff is that the share of my father already sold to Horendra Chandra Pal. So my father had no title. That is the case of the plaintiff. Here mentioned, my lord, that on 19465 sold to the Horendra Chandra Pal, and later on Horendra Chandra Pal same land to Fatima Khatun and Husnara Begum, and who later on sold the same to Amir Ali, and who also later on sold to Matlib Ali and others. So this is the plea of the plaintiff that whatever land my father Ismail Ali had, already he sold, and lost his title. This is mentioned from Horendra Pal to some Fatima Khatun to some Amir Ali to Motley Wali. Last Motley Wali is holding the share that was my father had. That is the case. So we had no title to transfer. But it is not backed by any evidence, my lord. I will go to the evidence. Plaintiff father stated that the principal defendants cannot sell the land beyond their share of 0.095 acre land inherited from their predecessor, but he sold 1 kadar so and so. So plaintiff's plea is that 0.095 is less than 1 kata of land, madam. If it is converted to kata, it is less than 1 kata of land. So they claim that after this sale, we inherited less than 1 kata of land. So we cannot transfer 1 kadar 5.2 gonda of land. But in the record, my lord, I will show your lordship that their claim that 4th schedule land is my land and it is 1 kadar 5.2 gonda. So there is a contradiction. Here they said that we did not inherit not more than 1 kata of land, but their claim is that with the 4th schedule land is 1 kadar 5.2 gonda. So we should transfer them the 4th schedule land. So there is a contradiction. In one side, their plea is that only less than 1 kata of land we inherited.
That is another schedule, no?
4th schedule, but the same dag and same patta number. The
Same dag and
same
same
schedule 1. All these lands are same schedule 1 in the mentioned manner. Plot 1, plot 2, and like this. So, my lord, next, that apart, the plaintiff also stated that when he discovered that principal defendants had sold the land belonging to pro forma defendant number to him, exceeding their share, he convened one village male at the house of Farman Ali PW2 to reconcile the matter, and which was attended by principal defendant number 1, plaintiff, Anchalik president, and other members of the locality. He further stated that after discussion, it was resolved that plaintiff will either refund 52,000 or recover of possession from pro forma defendant number 8. So the plea is that in the village bichar, 2 options was given to the defendant: 1 to refund the amount of 50,000 or to recover the possession from pro forma defendant number 8 and to deliver him. Plaintiff, in order to support his oral contention, also exhibited 2 documents, Exhibit 1 and 2, besides others, to show that the total area of land got by late Ismail Ali after amicable partition with Rahman Ali and total amount of land left out in the share of Ismail Ali after sale to Horendra Chandra Pal. So this Exhibit 1 is the sale deed of Horendra Chandra Pal, and Exhibit 2 is the subsequent sale by Horendra Chandra Pal. So these exhibits, my lord, I will show your lordship. In the schedule, there is clearly mentioned that the seller has some other land to northern side of the schedule. Perusal of Exhibit 1 and Exhibit 2 reveals that the share that is left out after sale of Horendra Chandra Pal is 0.095 acre within the area of plot number 1 of first schedule of the plaint. It also reveals that the said land measuring 0.095 acre is situated to the adjacent north of the sold of Horendra Chandra Pal. So from perusal of Exhibit 1 and Exhibit 2, it is clear that the share left out in favor of principal defendant number was so and so. That about plaintiff also submitted documents, namely Exhibit 5, in support of his contention on perusal of the reveals. Exhibit 5 is the, my lord, the decision of the male of the villagers bichar. This is a decision. Exhibit 5. Perusal of reveals that defendant undertakes to either refund 52,000 to the plaintiff or recover possession from the pro forma defendant number 8. In the last part of Magh month, the version of the plaintiff got substantiated by the aforesaid documentary evidence. But this document is, my lord, disputed by the defendant. He even disputed his signature in this document manner. PW2 and PW4 also narrated the similar version of PW1. Defendant number 1, on the other hand, did not deny the above fact. This is, my lord, a perverse finding, my lord. defendant number 1, the defendant appellant denied. But it is mentioned that did not deny the above fact in his WS. He never denied that there was no meeting as alleged by plaintiff, nor denied that he did not attend the meeting, nor denied that he did not sign the exhibit 5. This categorically denied, my lord. But it is held that not denied. I will show your lordship the evidence. my lord.
That meeting,
Yes, my lord. He,
it's exhibit 5.
yes, exhibit 5, my lord. All these are denied, my lord, but it is held here that he signed. Not denied that he did not give any undertaking to refund so and so to the plaintiff, nor to hand over possession of disputed land. Now, that being position, an inference could be drawn that defendant has admitted breach of duty on his part, misleading plaintiff, prejudice with intent to gain an illegal advantage or undertook return so and so. Because of Order 825 states, every allegation of fact, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of defendants, shall be deemed to be admitted except as against the person. So it is held that the defendant admitted, my lord. So on the finding that admission, on the basis of admission of the defendant, it is held correct. In the instant case, as the principal defendant, neither a person under disability, implication that there was no meeting and he did not put any signature. So it is perverse finding, my lord. It is held that that he did not state that he did not sign, but it is in the evidence that he stated that he did not sign, my lord. On the resolution of the meeting, unattended plaintiff to hand over possession of the thing. So we can safely presume that admitted his breach of duty. Further, it is pertinent to mention that the Honorable Supreme Court in the case of so and so held where there is no specific denial, an allegation made in the plaint, then there is no duty cast on the plaintiff to adduce evidence to prove that allegation. So in the backdrop of above discussion, I am constrained to hold that principal defendant has indeed sold the suit land belonged to predecessor of the Proforma Defendant 527 to the plaintiff by misrepresentation of fact. This is also not proved, my lord, that this land belongs to the principal Proforma Defendant number 527. Accordingly, point is decided in affirmative. Hence, in the backdrop of the above discussion, I am constrained to hold that learned Munsif has rightly appreciated the evidence on record while deciding issues at length. However, the decree granted by learned Munsif is, as per discussion held above, cannot sustain in the eye of law, nor the prayer made by the plaintiff legally sustained in the eye of law. As has already discussed, that only remedy that is available after completion of conveyance to the buyer is either to sue to set aside sale or claim to refund of purchase money or to claim damage and compensation. Now, in the instant case, as the plaintiff has not sought for such relief in his plaint, so prayer made by plaintiff and decree granted by learned Munsif cannot sustain in the eye of law. However, the plaintiff in his plaint in para 15C has prayed for any other relief to which he is entitled. So, taking into consideration the matter in its entirety, in exercise of inherent power of court laid down under 151 to secure the ends of justice, following relief granted to the plaintiff is entitled to decree declaring that the principal defendant shall return purchase money to the plaintiff amounting to so and so per annum with interest 6% per annum. So it is held that there is no prayer for refund of the purchase money and prayer. The
Your decree was set aside.
set aside.
Ah.
I think the decree was for executing a sale deed on Cyril 4. Cyril 4.
So that was set aside to return the purchase money.
Purchase money. The return of purchase money is, my lord, based that I have no title of the, but it is not supported by evidence. I will go to the evidence. So these findings are, my lord, I have.
Actually, now you do not want to return the purchase money.
But if the fraud misrepresentation is proved, if it is proved that I have no title, my lord, then I am liable to pay purchase money. But my lord, in this case, my lord, it is not proved, my lord, that I have no title, that I have misrepresented the, my lord. So, my lord, may we go to the, I think, my lord, the trial court judgment is required to read, my lord. Trial court judgment.
The witnesses.
Witnesses,
what
yes.
the witnesses have stated.
Yes,
See,
yes, my lord.
you have
Yes.
stated that you have denied exhibit 5.
Yes, my lord.
Let's see where you have denied exhibit 5.
Yes, my lord.
I think it will be in the trial court judgment or it will be in the evidence.
My lord, I think evidence.
Because we will not go to the evidence.
Yes, I think it is
What I say,
evidence, yes, my lord, evidence. The vernacular, it will be, my lord, I think.
if it is there in the trial court judgment that you have denied exhibit 5, then it's okay.
The witnesses supported his signature. Witnesses, plenty witness supported that he put signature. In para 52, para 16 of the trial court judgment. Para 19 also.
Page 19 years.
It is not mentioned, my lord.
Para 16 of the trial court judgment.
Yeah, 16.
16 of the trial court judgment. The appellate court has not altered the finding, only
Upheld.
Paragraph,
Modified.
paragraph
modified,
19, my lord.
based on the pleading.
Paragraph 19, my lord, of the page
Hmm.
25.
I'm relying on the paragraph 16 of the.
Not accepted in the class, not admitted signature. Paragraph 19, page 25, my lord. It is mentioned that the defendant number 1, your lordship got it, well, paragraph number page 25.
Yes.
Memo of appeal, paragraph 19, 19.
Okay.
19, it is mentioned defendant number 1 also denied signature over exhibit 5. He stated that the exhibit 5.2 is not his signature. And it is outcome of collision between the plaintiff and his cousin Amin Ali. So, but the appellate court held that the defendant admitted his signature, my lord. Amin Ali is the cousin brother of the plaintiff. And it is shown that Amin Ali's house, the bichar was held. So trial court held as per evidence that the defendant denied the signature and this bichar, he was present, my lord, his signature, but the appellate court held that the defendant admitted.
PW2, PW4, they have been stated.
No, he stated that his signature, you see,
My
there
lord.
are 19 only.
19. Defendant number 1.
Defendant number 1, he further stated that he put his signature exhibit 5.4 on exhibit 5.
Well, may I read, my lord? First, defendant number 1 also denied signatures. He stated that so and so is not his signature. It is an outcome of collusion between so and so.
He
But
denied only signature exhibit 5.2, but he admitted signature 5.4 on exhibit 5. So cannot be
Yes, my lord.
held that it is a perverse finding.
Yes, my lord.
My lord.
The other witnesses are admitting that fact of signature.
Yes, admitted exhibit 5.
Yes.
You want the LCR?
Well, I had the.
I have also not gone through the LCR, my lord.
You want the LCR?
Yes, my lord, I want to see my. Yep.
LCR of status food, I think will be.
Yes, my lord. Evidence will be in the title suit, I think.
The position of witnesses. You can continue. Also, if you want time, you can continue for tomorrow also.
My lord.
If you want to go through the.
Yes,
LCR.
he requires to go through, my lord.
Obliged, my
Hmm?
obliged, my lord. The part hand, my friend will go.
Kalikun Warin. My lord,
After the vacation.
my lord, in the next week, my lord,
No, not.
tomorrow I have some problem, my lord.
Then we will finish it today.
Yes, sir.
See, he's, one signature he has not admitted, but the other signature.
Yes, I'll go through the evidence, my lord. I'm going. As per evidence, I will submit.
You cannot say that, appellate court has.
Yes. Yes,
What
if
is the-
one signature admitted, my lord, that means admitted, my lord. That is right. Well, I will go through the evidence, my lord.
You want some time, then we will wait and we'll take up the other matters.
Obliged, my lord. My friend is
We can see, check the,
My
I
lord.
think he will also now, he has discovered something. He was
Yes, my lord.
Argument, his
Obliged.
argument, some contrary to his
Obliged, my lord.
contrary facts in his argument. We'll take up after afternoon. You can read the,
Obliged.
in the course itself.
My lord, I have another case fixed at 2. That is also a problem, my lord.
Then we will continue after the vacation.
I think that will be better. my lord.
Immediately after vacation, immediately.
So if my bench will sit, whether my bench will sit or not.
Lordship will keep it as a part hard matter.
I
Then-
can keep it as part of, but it's an old case.
Yes, my lord.
Well, immediately after vacation, my lord, on reopening. But immediately after vacation.
Bench or whether they, I'll be saying.
If it is part hard, my lord, automatically, whenever your lordship will go, it will go to your lordship.
It will come up before me. Yes, I can keep it part.
Yes, my lord. So I may continue to see the records now, my lord.
Obliged.
Lordship. One. I'll just dictate this order. Yes, what do you want to say?
Lordship, item 12 without informing me, adjourned lordship, item 12.
You stated that we have taken consent.
No, lordship, actually not. Thereafter, he has informed me. Then, but I have filed a early hearing petition. We have urgency, lordship, so let it be in the month of November. That may be fixed, lordship.
We'll fix it.
Fix a date, 15, 18, 20 November, lordship. Deeply obliged.
এখানে presence to deliver করো।
RB Bora, correspondent.
Partner argument submitted by learned counsel for appeal Mr. Emily Kadi.
Yes, yes.
Learned counsel Mr. A.R. Singhal is going to respond with this matter. You want a date or
It will 16th when?
16 November, October?
October.
November.
No, yes, October, my lord.
It's a yearly bill.
Thursday, my lord.
October, October, October 6,
Basically,
Yes.
October 16.
yes, October 16. So, argument आधा legal process. Argument आधा. उसी में bill number 1. OS detail.
They have filed a petition for transfer of.
Yes.
Your Lordship, an application filed under section 24, read with section 151 CPC 908 transfer for TSM 83/24, which is pending before the learned additional district Jorhat, Your Lordship. My only humble prayer is that Your Lordship, the lady, Your Lordship, the wife, Your Lordship, she has to travel from all way from Tezpur to Jorhat. And moreover that she is not.
I cannot.
Yes, Your
Yes,
Lordship.
boss. Any date, Lordship. 23rd will come.
23rd as a fixed item.
Obliged, Lordship.
Partner nala ya partner. Legally counsel
Lordship, before my learned friend begin,
This is 13 and 14, my lord, my ladyship.
before my learned friend begin, Your Honor, my story, item number 7 and mine is the same actually. It has been a long pass out date and the files were not found in my chamber as of now. So I could also like to pray for some. No, we are engaged. Yeah.
He's been
Please,
there
please.
for long. My ladyship, this matter has been heard, reserved for 2 times, and now we are on the 3rd time. And now he making this kind of submission, I don't know what to say also, because this is a classic case where court divested me in a suit for specific performance. I am allegedly the vendor, and the court says you are not the owner of the property. Then his appeal also is to be dismissed at the threshold.
It was heard at length and then.
Yes,
Then
Your
the-
Honor, it was in
Court-
2023.
This
I sincerely apologize.
Yes.
I
So
sincerely
that's why I
apologize to
want
my
to
court
take
and
my
to my land council also, because I know he has came a long way. But Your Honor, I'm
I'm from Delhi, my ladyship.
I know I'm very.
But had this happened earlier also, my friend.
Conferencing.
But this matter. is
Lots
to
of
be
this
done
matter, this video
physically
conference
because-
will not do.
But
What the-
This is a classic case, my ladyship, because here the court divested him of my ownership in his specific suit for performance.
Can I leave it as partner?
Yes, that will be. I'll pray for
Lots
Will
of
be over.
Lordship, if the court wishes to say that, then I have nothing. But if the court allows us, because both the matters are in same matter, it's a big longer matter actually.
No. It's one very short issue. First of all, my ladyship has to decide whether the owner can be divested of his title when he is admitting it in his plaint, in his evidence. Can the court take a contrary view? This is an admitted fact under section 58 also. There are so many judgments of the Supreme Court. Admitted fact need not be proved. And on that very issue, the court says you are not a owner.
Lordship, in this matter,
And can he now raise this, or can he object to this that I am not the owner? Otherwise, his appeal gets dismissed on the threshold.
Lordship, in this matter, what I remember is that the RFA which they have filed it, I had read one the objection of maintainability.
Why maintainability? Because the thing is that they have not taken the power of attorney of who is filing the RFA. On that ground, it was said. Then the honorable court, maybe I just forgot the court name actually. Then he said, okay, we kept your RFA aside. We will begin with you, with me. My RFA number was 111/2019. And that much I remember actually. So the thing is that I pray again to this honorable court.
Two RFAs.
Yes, one by him
two RFA and
one is by the vendor and another is by the vendee.
And in thing is that in item number 13, I am the counsel, my name is not been appearing, whereas in item number 14, my name appears on both sides. I am the respondent also and the appellant also. So this may be rectified, and I again pray to this court ki just 7 number item, the same thing was because it was 2023 matter. I do asked my forgiveness that the file should not have been missed because it's a huge volume. But yesterday there was a Vishwakarma Puja. I saw in the cost list. Then I failed to detect the files actually.
Anyway, I'll leave it to my ladyship, but otherwise the issue, either my ladyship takes my matter or his matter, the issue remains the same. Can the court divest the owner of his title in a suit of specific performance filed by him, the vendee? And particularly after recording of categorical findings, the vendee has played a fraud on the court and everything is a fraudulent act on his part. And in that same breath, it says the owner itself is not the owner.
In this matter, I could not go into
This is a judgment. Whether you, my lord, my ladyship takes my matter or his matter, the law remains the same, that the owner can't be divested. My ladyship had a long tenure during that time also. This is a classic case where the court has divested me of my title without there being any challenge also. Admitted fact. In his first line, he admits I am the owner. And now he is wanting to challenge it in his suit for specific performance appeal.
My lordship, what I pray, 7 number item is also the same item only. We can fix the fixed date for this one or fixed date because the reconstruction of the file will take some time.
I'll give him a copy today. I'm not objecting to, because we also face the same problem. My office got burned down in Delhi because of some explosion or something like that. And we had to also reconstruct the files. So I am not on his part. We will give him a copy today itself. I'll get a copy made and sent to his office free of charge.
Office got burned down.
Well, in Delhi, my lord, because yes, some mid of the night, some explosion happened and everything got burned down. And then the neighbors lodged a FIR against us. But that's on one part. So I am not on this aspect. We'll give him a copy. We'll give him both the copies, his appeal also, my appeal also. There's almost the same, whether my ladyship takes his matter, my matter, whether there is a technical difficulty in my matter, but the judgment is the same.
You are the vendor.
I am the vendor. Now I am allegedly the vendor.
It's up to you. You can submit your part.
I can just take my ladyship to the.
You can submit your part, then you don't have to come again.
No, I can come because in this matter, I can come again, my ladyship. That's not an issue. Not a much.
Your Honor,
I have matters in Meghalaya also.
Your Honor, better because both of us should be there. I mean, while we have argued on that matter, we also realize that both of us should be there. So please, Your Honor.
You will be there.
Yeah, I will be there.
When you will argue, you will be there. Of course, you are here now.
Yeah, I'm here. Your lordship was saying ki let him argue the matter so that he may not come again for this matter. We can. So what I am doing.
Video conferencing, because that part he doesn't have to submit.
Lordship, that is very true. But in this matter, I personally say that video conferencing will not do actually.
When you submit, he will be present for video conferencing.
Yes.
Okay, fine. That can be done.
Yes. Then he need not come again.
That can be done.
I'll read from.
Then he can reply to video conference.
I'll
Then
read.
he can
Yes, you're right.
I'll read from his paper.
clearly and reply.
Yes, Lordship.
I'll read it from his paper book. Because lest my learner friend will
Yeah,
make an allegation that there is some
one.
technical difficulty.
RFA
Item
number
14.
60 or 111?
14, 12, double one, my ladyship. RFA 111, sorry.
111. It will result in.
Otherwise, the LCR is also recorded because I remember there is an order. LCR has been,
LCR.
yes, LCR is there.
Okay. Yes,
I'll take my ladyship first to the have,
I'm taking 111.
yes, 111. Page 44. I'll just take my ladyship to this issue. Issues are framed at page 38 of this paper book. I'm more concerned with issue number 10. Whether the defendant oblique counter claimant is entitled to the decree and relief as prayed for. This issue is whether the defendant counter claimant is entitled to the decree and relief prayed for. The counter claimant D1 deposed that he is the owner of the land measuring 1 Katha 17 Lecha covered by DAG number 200 of KP Pata number 87 of Revenue Village Khanapara under Baltota Mauza in the district of Kamrup, Assam. DW1 disposed that he purchased the same land on 5th of March 2012 and one Upindra Chaudhary by paying an amount of rupees 25,90,000, who was the original owner of the land, sold the land to him by executing a sale deed number 1930 dated 5th of March 2012. The defendant counter claimant did not exhibit the sale deed number so and so 1930 or any other land documents of copy of Jama Mandi to show his title over the said plot of land. In the absence of any evidence to show that the defendant counter claimant is the owner of the scheduled land, it cannot be said that he is in any right, title and interest over the same, and as such the right, title and interest of the defendant over the scheduled property cannot be declared. However, as issue number 4 and 5 are decided against the plaintiff, it is clear that the sale agreement dated 10th of October 2013 between the plaintiff and the defendant is forged, manufactured, void, collusive and incooperative and not binding upon the defendant. The issue number 1 is decided partly in the affirmative. Now kindly come to, my lord, his suit is annexure 1 at page 11. What was the suit filed by the appellant here? That is Shri Alok Ghosh. This is a suit for specific, my ladyship is on page 11.
Yes. Yes.
This is a suit for specific performance of contract dated 10th of October 2013, confirmation of possession and for permanent injunction. The suit is valued at 1 crore for the purpose of jurisdiction and court fees. For injunction, the suit is valued at 100 and ad valorem court fee of 11 and on 100 has been paid separately. That the defendant is the absolute owner and possessor of the plot of land measuring 1 Katha 17 Lecha 4.92 can't be acred, ARE, covered by DAG number 200 of KP Pata number 87. And in the second para, he says that in the month of September 2013, the defendant approached the plaintiff with request to sell the suit property, and upon agreed, both the parties on 10th of October 2013, the defendant with a view to sell the property to the plaintiff entered into an agreement. As the said agreement, the price of the suit property was fixed at 1 crore and was fixed at the defendant has accepted an amount of 90 lakh. The only as advance on the day of execution of the agreement for sale dated 10th of October and has handed over possession of the suit property to the plaintiff who is keeping the same under his exclusive possession till date. Now what has happened is he takes the possession in the October 2013. Our case is that he forcibly takes over the possession and everything is forged and he's continuing till date, whereas this particular issue number 10, which is decided against me, divested me of any right over the property and title to even seek the means profit from him, because the court has declared that agreement to be forged and fabricated. So in both the breath, my lord, the same thing. His suit is dismissed, my counter suit is dismissed, and then he is enjoying the property because possession of the property is with him now.
The vendee is enjoying the property.
Yes, my ladyship. The vendee who has got no right over the property has now become the absolute owner in terms of that I have been now divested. I'll just quickly take my ladyship to section 58. First of all, let me just deal with this particular. Just have section 58 of Indian Evidence Act.
Okay.
That is chapter 3. Because what has happened in this matter is under chapter 3, court in while deciding issue number 5 takes a judicial notice of another evidences which this honorable court had permitted us to provide to the honorable trial court. So after taking the permission from this honorable court, which he did not object and did not file any appeal thereafter, we were allowed to exhibit certain documents which the court was to supposed to take notice under the chapter 3 judicial notice, read with order 13 rule 10 certified copies. Now kindly have this particular 58. No fact need to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at any time they are deemed to have admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admission. Here the court did not even ask me to prove certain thing, because he had already admitted, and it is a suit under the Specific Performance Act. It is deemed that I am the vendor only. So I need not even have proved my title when he is himself admitting that fact. Now the court has dismissed his suit and in the same breath divested me of my right over the property. And then there are plethora of judgments also. But then there is another aspect why his appeal need to be dismissed also now. And that is the issue number 5. It's one very small issue.
Yes.
This issue is whether the defendant has obtained rupees 90 lakh from the plaintiff as earnest. My ladyship, this is at page 42 of this very paper book.
This is very important.
This is the second, because first of all, I have to establish my right, my ladyship. If I don't have the right also,
Yes.
I can't even argue anything against him. Kindly have issue number 5, para 17. Plaintiffs as PW1 deposed that on 10th October 2013, he paid an advance amount of rupees 90 lakh to the defendant. The plaintiff, however, did not exhibit any money receipt in the instant suit to show that such payment was made to the defendant, and same was duly received and acknowledged by the defendant. PW2 in his cross-examination deposed that on the day he signed the exhibit 1, only part payment was made and he does not about the exact amount. PW1 in his cross-examination deposed that he paid an advance amount of rupees 90 lakh, arranging the same in family, and his sister Swati Ghosh and friend Abhijit Roy are the major contributors in arranging the money. PW1, however, did not adduce evidence of Swati Ghosh and Abhijit Roy to prove that they are arranged the money payable to the defendant by the plaintiff. The plaintiff also did not submit his bank statement or bank statement of the bank of Swati Ghosh and Abhijit Roy to prove that any money transaction was made. PW1 deposed that he lodged an FIR against the defendant on 15th of May 2014. The said FIR was Exhibit A. On perusal of Exhibit A, it is seen that the 2 numbers of money receipts are endorsed, and taking judicial notice of the certified copy of the 2 money receipts which are in the case record, it is seen that the money receipts are dated 21st of March 2013, 12th of August 2013, and 21st of March 2013. And in the money receipt, Preetham Hazarika and defendant number 2 signed as witness number 1 in his cross-examination. PW2 deposed that he heard that the defendant issued money receipt, but he is silent that he had put his signature as witness in this money receipt. Moreover, the certified copy of the money receipts reveals that these money receipts dated 12th of January 2013 and 21st of March 2013. Whereas, as per the deposition of PW1, the agreement for sale was executed on 10th of October 2013. So, considering the above, it appears that the plaintiff failed to show that there was any money transaction between the plaintiff and the defendant, and thus it is held that the defendant did not receive rupees 90 lakh from the plaintiff as earliest. The issue number 5 is decided in the negative and against the plaintiff. Now I'll tell my lord, my ladyship, I'll clear this. What has happened is he set up two different pleas. One plea was before the police where he showed different receipts of a different time frame for the same year, that is in the month of January and March, of different denomination, and those are in my paper book in the RFA 73. Those are exhibited also. They are of 15 lakh and 45 lakh, and one receipt in the FIR it is mentioned. These are all the part of the FIR which he lodged before the police, which ultimately is closed on the ground that it is he who is to be prosecuted under the Assam Land Grabbing Act, and they proceeded, but nothing has happened against him. But B holds that two receipts are found there. Those two receipts ultimately found their way to the Honorable Trial Court and before this Honorable Court, which granted us the liberty, and the court takes a judicial notice of. But before the trial court in the civil side, when he files a specific performance, he files Exhibit 2.1, 2.12 and 2.13. They are of 30 lakh each, and they are all from the month of September, because as I read para 2 of his plaint, he says he never came to know of the defendant prior to September 2013. But he adduced some forged documents earlier before the police showing predated receipts of 15 lakh, 45 lakh and 30 lakh each, totaling around 90 lakh. Here also he shows, but when it came to the knowledge and it was put to him, he denied of having ever placed those receipts before the police. And the police document are all signed by him. Those receipts are also signed by him and not by me. Whereas what he produces before the civil court are all the receipts signed by me, no witness, none his signature. So he is a paying person there. He does not sign his signature. He just takes my initial, which I admit of having endorsed the signatures only, not the content. The document which is under specific performance, the agreement to sell, is not even proved. I don't even admit my signature on that. His appeal is only for on the ground that the signatures which I have admitted on the receipts have to be considered for the agreement also. And if my ladyship proves both the signatures from the LCR, both the signatures are totally different. One is only initial, which is on the receipt, money receipt, and what is initialed on the agreement is totally different altogether. So his suit was rightly dismissed, but in the same breath, my suit counterclaim also, even though I should not have actually filed my declaration for title when I am admittedly the owner, but some or the other, they filed a counterclaim wrongfully, but the court fell in grave error by not recording a finding that once it is an admitted fact, it should not have been proved and the issue should have been decided in my favor. Now I'll take my ladyship to the receipts also, because those receipts are very important. Then my ladyship will know why I am agitating so much in this matter. And since I am out, and he has also placed, luckily for me, he has also placed all those two orders before my ladyship. At his page 47, my ladyship. Sorry, I apologize. Page 52. Next year 5.
Okay. Page 52, yes.
Since the FIR was only produced by us in the trial court, exhibited, but those money receipts as well as the power of attorney signed between the parties or allegedly signed between the parties was not placed on record. We moved this particular application and that was decided on 11th of October 2018 and the court rejected those but granted us a liberty at page 59. The trial court, this is a trial court's order. I would not take my ladyship to much of the details here because those are not required. Page 59. However, the petitioner defendant is at liberty to produce certified copy of the money receipts dated 21st March 2013 of 45 lakh and 12th of January 2013 of rupees 15 lakh, submitted by the opposite party plaintiff as informant along with the ajar on 15th of May 2014 at the time of hearing argument to enable the court to take judicial notice of its contents and decide the suit accordingly. Now, I filed another application also. That was also under order rule 16(7)(a), read with section 151. I would not take my ladyship to this also. Here also the court granted us the same liberty. This one was for production and one was for placing on record the certified copy, page 65. That's the same order. Then when it was rejected, we filed a case before this honorable court, and that order my ladyship may find in my petition. I'm so sorry, otherwise I would not have taken my ladyship to my paper book, but that order is at page 58 of RFA number 73.
Page 58.
Yes, I'll take my one second. My ladyship, give me a second. That order is probably not on record. That order is not on record. But those money receipts are. Kindly have those money receipt at page 85.
Triple one.
No, at 70 in 73. Those also will be in the LCR. We have page 85. This is money receipt of and it is detailing the same has received an amount of rupees 45 lakh against the total consideration amount of rupees 1 crore from Shri Alok Ghosh, son of so and so at so and so. This date is 21st of March 2013 and witnessed by Preetam Hazarika and Vipul Singh, signed by me, allegedly, Chandra Mohan Jha. This is forming part only of the FIR, not in the trial court. And he does not even deny this in his appeal also. And the second is at page 86. This is of prior date, 12th of January 2013. Same witnessed by Preetam Hazarika, Vipul Singh, and signed by me. Now kindly have his FIR. That FIR is at page 68. Typed version. Otherwise, the page 66. FIR number 902, dated 15th of May 2014. And the typed version starts at page 68. This is dated 15th of May 2014 to the officer in charge, Dispur Police Station, Guwahati. With due respect, I beg to inform you that the last year, that is on 10th day of October 2013. Now the dates will come the same, my ladyship, except the money receipts. I have entered into an agreement with Shri Chandra Mohan Jha, son of Haridev Jha, aged about 59 years by religion, Hindu, resident of Modrina Mansion under PS Laitungkhra, Shillong, East Khasi Hills, Meghalaya, in regards to a plot of land measuring 1 khatha 17 lechas covered by DAG number so and so.
You are looking at which page?
Page 68, my ladyship. This is a copy of the FIR, a typed version. This is a I am reading from the top. Page in RFA number 73.
Dispute PS case number 902 of.
Yes, my ladyship. This starts at page 66. And since.
No, here pages are a little bit different. Here it's type version is page 70.
Very well. I'm so sorry, my ladyship, but then I'll correct all the things.
Which paragraph?
I'm reading from the top, my ladyship, because this is very, very important because the dates are the same. The date of the agreement remains the same. With due respect, I beg to inform you that last year, that is on 10th day of October 2013, I have entered into an agreement. FIR is at 902. There are two FIRs. One is lodged by us and one is lodged by them. Mine is a little earlier in time. Mine is at page 47. That is 1060. Mine one.
No, the pages are should be different.
Then I'll get them corrected, my ladyship. I can only seek time.
The prayer portion of the title suit here.
Very well. We'll just get it corrected, my ladyship then. Then I would not waste my ladyship's time.
Yes.
Then we'll get it corrected. But otherwise, there are only two issues involved. One is against me that I have been divested of my property. And secondly, he sets up two different diametrically opposed claims. One before the police for the same transaction for a different period, different amounts, receipts also. And one before this, before the trial, before the civil side. He completely ignores what he has done earlier. He starts his dates and events from the month of September, and he category a question is also posed. Did you knew this guy before September 2013? And he answers, says, no, I did not knew about him. That means all the money receipts which he placed before the police authorities were totally forged. And these ones are also forged because no money came to be given to us. And now he is enjoying free of cost this whole property, which is quite a big property here, for free of cost from 2013 onward. And he was only a contractor for us to build that property. This is like camel and the Arab, my ladyship, where the camel has taken over the tent.
And that's what they.
And there are two more cases against him under the Land Grabbing Act. Very well. We will, then I'll do the needful, my ladyship, with regard to the paginations. If a small date can be given, or whenever my ladyship's, because there is a roster now of the direction by the Honorable the Chief Justice with regard to listing of the matters. So if it can be immediately after those motion matters.
Yes, yes.
So grateful.
After motion matters, it will be after the vacation.
Very well, my ladyship. And if we have waited for so long.
November 18th will do if he's not.
I will be there anytime.
November 18th.
It will be convenient to my friend because whenever I take a date, he never is there.
13-14 is there, no?
13-14.
Learned Counsel, Mr.
Amanpreet Singh.
A. Singh, no?
Yes, my ladyship. Amanpreet Singh. Mr. Kalita is our counsel. And Japneet Singh from the office of BTK.
Is present
They are not there right now.
for, so we will start with
111.
111.
Yes, my lady.
Is present part-heard argument due to agree club ko likhi diba. Part-heard argument, Learned Counsel, Mr.
IS
IS Majumdar is
Majumdar.
present. List this matter on 18th
18
November.
Grateful, my ladyship.
It is club ko likhi diba.
Grateful.
Item number 111 of Bhujla Bhana. It's 13 is none.
Your Lordship, my senior is on the way.
Huh?
So my senior is on the way. She's coming.
Goes on his way.
Yes.
Always. Next to Madhya. Sitting there from here to side. Item number 15?
16.
Yes, 16, yes.
Lordship, this application, the appeal was filed against the judgment and order dated judgment and order dated 23/9/2019 of the Railway Claims Tribunal.
Sorry. Well, these appeal we have filed against the judgment passed by the Railway Claims Tribunal, Guwahati Bench.
Yes.
The influence judgment, your lordship will find at page
31. That says 31, your lordship finding in judgment. Well, after going through the judgment, your lordship will find certain findings have been given by the Railway Claims Tribunal. Firstly, my lord, tribunal has raised doubt about the journey ticket. Journey ticket was mentioned in the claim petition itself. At the time of filing the claim petition, in the claim petition itself, it was mentioned that there was a journey ticket, valid journey ticket. It was mentioned. At the time of adducing evidence, the ticket was produced before the tribunal. That's why tribunal has raised doubt about it. Secondly, tribunal has said that dependency has not been proved in this case. I will show the provisions of law. Your lordship will see dependency need not be proved in our case. There are categories of dependents. Some dependents have to prove their dependence, and some dependents they need not prove. Law does not require any proof. I'll show you, lordship. So, ultimately, the claim petition has been dismissed that he was not a bona fide passenger, and the relation certificate. The question has been raised about the relation certificate. Relation between the deceased and the claimant. Claimants are this minor son and daughter of the deceased father. Father died, leaving behind minor son and daughter. Mother of the minor children, pre-deceased.
Okay.
They died long back before the death of the father. They were brought up by their maternal aunt. She has represented the claim petition. Now, my lord, this is the background. The claim petition has been dismissed. Now, my lord, I'll read the influence argument at page 31. The present application is filed under section 16 of the Railway Claims Tribunal Act 1987, read with section 124A of Indian Railways Act 1989, claiming compensation of rupees 10 lakhs with interest for the death of the deceased Abdul Sattar, aged about 42 years, alleged to have died in an alleged untoward accident that occurred on 21/2/2016. As for the elements disclosed in the claim application by the applicant, the deceased fell down from up intercity express train at platform number 1 of BDGH railway station while he was traveling from Badulvar to Jorhat railway station with a valid journey ticket number so. As a result, the victim received grievous injuries and was shifted to Community Health Center, Dergaon, by 108. But considering his seriousness, he was shifted to Jorhat Medical College, but was referred to Assam Medical College or GMC Guwahati, where he died. In this regard, forgetting VRP OP GD case number so dated 21/2/16 was registered. As per para 15 of the claim application, the victim left behind one daughter and one son as the only dependents. Both the claimants are minor, so the case has been filed by the maternal aunt Timothy Mosliha Begum, sister-in-law of the deceased, since the wife of the deceased, namely Musfika Begum, died on 8/12/2007. But death was registered on so. It will not be out of place to mention that earlier a case was filed for same cause of action, being number so, which was withdrawn by the order dated so along with the claim application. Since claimant was minor and the original application lacked details and documentary evidence in support of governments contained in the claim application. The claim application is accompanied by true copy of police report, true copy of SM memo, true copy of ticket number so dated so, true copy of GRP report, true copy of death certificate, true copy of birth certificate of Miss Shahin Akhtar Ahmed, true copy of birth certificate of Ashraf Tanvir, true copy of discharge certificate issued by JMCH, true copy of CT scan report, true copy of laboratory certificate, photocopy of medical report, photocopy of money receipt, photocopy of translated copy of ration card, true copy of post-mortem report, true copy of HSLC certificate of Shahin Akhtar Ahmed, true copy of government Gaonbura certificate, true copy of voter ID card of Masliha Begum, along with the claim application. So all these records are submitted, my lord, along with the claim application. Next, para 3, the respondent filed WS and DRM report and disputed and denied the averments made by the applicants. As mentioned in para 6, the respondent denied that the victim was fallen down from up intercity express train due to any fault of respondent on sensor. The victim might have died. This is totally surmises, my lord. The victim might have died due to his own negligence. As mentioned in para 15, the respondent also submits that the relationship has to be proved by the documentary evidence. The respondent also states that the applicant has to prove the dependency by producing dependent legal heir certificate from competent authority. This respondent puts the applicant to the strictest proof, denying the liability for compensation. With this averment, the respondent prayed for dismissal of the claim application is caused. Based on the pleadings, issues were framed on censure. However, for just decision of case following, issues are reframed as under: whether the victim was a bona fide passenger, whether the victim died in an untoward incident as defined under section 123 C2. Well, this C2, section 123 C2, it has been wrongly interpreted and wrongly applied to our case. This provision of law does not apply to our case. Our case is covered by section 123 C1. I'll show you, your lordship.
Okay. So this issue number 2 of.
Yes, wrong provisions of law was applied, and on that basis, claim petition has been dismissed. I'll show you, your lordship. Whether number 3 issue, whether the applicant is sole dependent of the deceased. Number 4, relief. Determination and findings on issues. For sake of convenience, issue number 1, 2, 3 are jointly taken for decision. The present case applicant, as being minor, are represented by Masliha Begum's sister-in-law of the deceased on behalf of claimant, namely Miss Shahin Akhtar Ahmed, the daughter of the deceased, and Ashraf Tanvir, the son of the deceased, on account of death of late Abdul Sattar. On perusal of case record, it is seen that earlier claim application bearing number so was filed for same cause of action by Miss Shahin Akhtar Ahmed, daughter of Abdul Sattar, which was withdrawn by the order dated so. Since the claimant was minor and the original application lacked details and documentary evidence in support of averments contained in the claim application. On perusal of claim application, it is seen that although there is a mention of ticket, my lord, the ticket was mentioned in the claim application. Although there is a mention of ticket number of deceased in the claim application regarding the same belonging to the deceased to show that he was a bona fide passenger, but no original ticket was filed. It has also been noticed that during the cross-examination, the sister-in-law, Masliha Begum, who appeared in the court as AW1, averred that she is filing the ticket today, that is on 7/8/2019, which has been handed over to her by the police officials to her. These statements made by her and her act of filing the ticket along at the time of evidence cast doubt and does not inspire confidence, more so in absence of seizure list as a proof of seizure of ticket and containing no endorsement of police seal, etc., which means the oral and documentary evidence placed on record by the applicant and the respondent railway proved that the ticket filed is not the one belonging to the deceased. In absence of any cleansing evidence, my lord, kindly see cleansing evidence required as per the tribunal, as if it is more than criminal case. Cleansing evidence, they want. Cleansing evidence, I am unable to hold that the ticket belongs to the victim. Since the journey ticket was recovered by the station master, nor the GRPs, and on the contrary, we see that the ticket was handed over by the AW1, namely Srimati Muslima Begum, on 7/8/2019 itself, that is the day of evidence, and no UD case being registered in connection with the incident, it is difficult for me to hold that the deceased was a bona fide passenger. Regarding UD case, my lord, I'll show your lordship, it was registered. GD entry was registered. UD case registration, it is up to the GRP authority. The GRP authority cannot be compelled by the claimant to register UD case. GD entry was made, number is there, everything. Next, my lord. It has been further seen that the original ticket is not reflected in public documents filed along with the claim application. No seizure list, the inquest report, the final report, etc., has been furnished along with the claim application. Even the memo that it has stated that one unknown male person aged about 55 years fell down from so-and-so up running Intercity Express at so-and-so hours of platform number 1, call for 108 and arrangement to Dergaon Hospital, which clearly reflects that they had not made a proper inquiry. My lord, the finding has been given. The GRP personnel, they did not investigate properly. They did not inquire into properly. Regarding the injured, or else his name would have clearly written there in place of unknown male person. One more question can be cropped up regarding the age as mentioned in the SM memo is 55 years, and the medical report speaks about 41 years and 43 years, which is not constant in nature. It is further seen that various documents filed along with the claim application are photocopies and are not certified copies, which does not inspire confidence for the case itself. It is pertinent to note that the initial burden lies on the applicant to show that the deceased was a bona fide passenger and died on account of an untoward incident, and only on the discharge of the said initial burden, the onus shifts on the respondent railway to establish that the deceased was not a bona fide passenger and the incident is not an untoward as held by the Honorable Court of Andhra Pradesh in the case of so ACJ 1061. Under section 124A of the Railways Act, a dependent claimant can seek compensation for the death of the deceased person on claimant can seek compensation for the death of the deceased person only on establishing that the death was due to an untoward incident. Though the provisions contained in section 124A of the Railways Act are beneficial in nature, they are meant to subserve the interest of the genuine victims of an untoward incident. The compensation paid from the public exchequer is not meant to compensate for the misdeeds of the passengers who do not abide by the law. In the present case, the evidence on record does not establish that the deceased was a passenger of any train or a bona fide passenger, and his death was due to any accidental fall from the train carrying passengers amounting to an untoward incident. Since it is not a case of accidental fall from the train carrying passengers, view of the findings on the above issue is in negative. So, my lord, here the tribunal has applied personal knowledge. Personal knowledge cannot be imported to decide this type of case. Series of judgment is there also. In absence of legal and valid document regarding dependency, as required to be shown under section 123B2, which may prove their being sole dependents of deceased, and in absence of applicants not filing any succession certificate and the document A14 and A17, which has been filed by the applicant, can't be relied to prove dependency since it is not certified copy. Therefore, I am of the opinion that there is no credible evidence on record to show who actually are successors to the estate of the deceased. Therefore, the evidence on record does not establish the dependency of applicants as mentioned in section 123B2 of the Railways Act 1989, which states that dependent means the parent, minor brother, or unmarried sister, widowed daughter-in-law, and a minor child of a predeceased son, if dependent wholly or partly on the deceased passenger. The other parts not important. So, my lord, your lordship has seen, as I have pointed out in the very beginning, that certain findings have been given which are not either legal or which are not as per the facts of the case, which I'll show you. My lord, before going to discuss the findings of the tribunal, certain records your lordship will kindly go through, then the matter will be easier to understand clearly. In the appeal memo, we have annexed certain papers, my lord. My lord, kindly turn to page 9 of the appeal memo.
Okay.
Page
9,
9,
yes.
page 9 of the appeal memo.
No.
This is the annexure 1. It was issued by the station superintendent to the OC GRP for cutting. This memo was given, and it is written in the Lordship, sorry, kindly come back to page 8, translated copy. We have given the translated copy.
Page 8, okay.
Yes, page 8, translated copy of the memo. One unknown male person, aged about 55 years, fell down from so up running intercity express train at so hours at platform number 1.
So this is the GD entry.
Yes, madam. Initial document, this is the initial document. Immediately the matter came to the knowledge of the station superintendent. He issued this memo to the concerned GRP. And they called for the 108 and shifted the injured person to the hospital. Next, Lordship kindly turn to page 10, annexure 2. This is written by the in-charge for cutting GRP outpost to the superintendent of civil hospital, Dargaon. Prayer for medical examination and treatment. I am sending here with the following injured person who fell down from so-and-so up running intercity express train at so-and-so railway station, platform 1, for favor of medical examination and treatment. my purpose, my lord, to take your lordship through these papers, just to show
I understand.
all the authorities have mentioned, they found a person injured who fell down from the intercity express. Everybody has mentioned fell down. It is a case of clear falling down now. Next, your lordship kindly turn to page 12. Death certificate. The card death certificate, Abdul Sattar, no? The
That's a.
death certificate of the deceased. Yes.
Abdul Sattar.
Abdul Sattar, my lord. Abdul Sattar, he is the person, he died in the accident. Abdul Sattar, death certificate. Next page, my lord, page 13, annexure 4. This is a translated copy of the journey ticket.
Okay.
The journey ticket. Next page is the original photocopy. Annexure 4, page 14 is the original. Next page, lordship, annexure 5. This is the police report. Type copy of the police report. This is to certify that on so at so hours, one railway memo was received from Amarkant Sinha on duty station superintendent, Borua Bamungaon Railway Station, NF Railway, to the effect that one unknown male person aged about 55 years fell down from up so-and-so running intercity express train at so-and-so hours at platform number 1, call for 108 ambulance and admitted to the Dargaon hospital. In this regards, matter was entered. My lord, kindly see here, finding has been given by the tribunal that no case has been registered. That in this regards, matter was entered for cutting GRP outpost wide GD NT number so-and-so dated 21/2/2016. At so-and-so hour and investigated into. Matter was within the knowledge of the GRP personnel. GD entry was made. Next paragraph. During investigation, it is found that the memo of the injured person was Abdul Sattar, aged 45 years, son of so-and-so, Jorhat, so-and-so. As a statement of injured person, he was traveling. The injured person gave the statement. He told that he was traveling from so-and-so to Jorhat town by so-and-so up intercity express train by traveling ticket number so-and-so dated so-and-so. The injured person unable to say how he fell down from running train and where. As a result, the injured person Abdul Sattar got grievous injured on his head and left leg and immediately admitted to the community health center Dargaon. The injured person Abdul Sattar was handed over to his close relative Mafizur Rahman, so-and-so, hence the case. And the injured person was handed over to their close relative. Next page, my lord, this is the GD entry, general diary. Next page, page 16, ma'am.
Yes.
Annexure 5. Now, Amarkant Sinha, station superintendent, Borua Bamungaon NF Railway, informed at this police outpost through a written memo that an unknown person aged about 55 years has fallen down at platform number 1 at so hours from the running up intercity express train and has been admitted into Dargaon Civil Hospital with the help of 108 ambulance. In this regard, officer in charge, DRP, was informed and prayed to visit Dargaon Hospital and take necessary legal action, and the case has been registered. The case was also registered. It has been mentioned here. Investigating officer and staff attended at the police outpost. Now I have taken charge of the outpost with the staff. It is mentioned that on receipt of the memo in connection with GD entry number sensor visited.
Yes, it's okay, I'm ready.
Yeah, my lord. So, my lord, everywhere this In all the records, it has been said clearly that it is a case of falling down. Ticket is also there. Ticket has been seized. And subsequently, it was handed over to the relatives of this injured person. Everything has been mentioned here. But unfortunately, the tribunal did not apply mine. All papers were not gone through on personal knowledge, gave the finding and dismissed the petition, saying that there is no journey ticket. Hereafter, my lord, certificate of birth certificate. My lord, kindly turn to page 23.
Page 23.
Annexus, yes, page 23, Annexus 7. This is the birth certificate.
Birth certificate of the girl.
The girl and son.
Son, yes.
Yes, both certificates are there.
I've seen. I've seen.
Yes. Shaheen Akhtar Ahmed, page 23, Shaheen Akhtar Ahmed, the girl is the first issue, then the son, next page. Birth certificate of both we have given. Thereafter, my lord, kindly turn to page 25. This is the high school leaving certificate examination. Shaheen Akhtar Ahmed, father's name Abdul Sattar. She passed high school leaving certificate examination and she got first division medal. This is the page 25. Next page, my lord, 26, Annex 9. This is the certificate given by the circle officer, revenue officer. My lord, immediately after, at the time of death of the wife of the deceased, Abdul Sattar, wife of Abdul Sattar died earlier, leaving behind son and daughter.
Yes.
The daughter was at that time aged about 4 years, 6 months. And the son was 1 month, 6 days old. So immediately after death of the mother, both the children were brought.
Brought up by her.
And yes, maternal. She brought. And that has been certified by the circle officer. Oh, next, my lord, page 28.
Ration card.
Ration card, madam. Here below, your lordship will find full name. There are some column, serial number, full name, age, relation. Abdul Sattar. Name of the deceased, Abdul Sattar. Shaheen Akhtar Ahmed. Then Ashraf Tanvi, daughter and son.
Yes, yes.
So, ration card, madam. Next, my lord, this is important document. Lordship, kindly turn to page 30, Annex 11. This is the enquiry report. Enquiry report. Yes, enquiry conducted by the railway authorities. It speaks many things, my lord, about the ticket, about how the incident was handled, how it happened, everything. I'm reading, my lord. Please refer to number so-and-so, letter number so-and-so, dated so. My lord.
The finding is that that it might have happened due to his own carelessness for which
Yes.
that is the finding.
In the first para, my lord, it has been clearly said this journey ticket. It was seized by the authorities.
Yes.
Then a seizure list was made. Then subsequently it was handed over after making the Zimmanama. Everything has been said. But the tribunal held that no seizure list.
So how much compensation you were claiming?
My lord, 10 lakhs.
10 lakhs.
10 lakhs. Actually, my lord, there is a schedule. The amount of compensation, there is a schedule there. For that schedule,
Can you show me the schedule?
yes, my lord, it will be here in the act itself. I think. Now it is 8 lakhs, my lord. 8 lakhs is fixed for death case, and the different categories of injuries, there are other. Yes, my lord, it is there, amount of compensation payable in the respect of death and injuries. For death, it is.
It will be according to,
My lord,
according to the rules.
according to the rules. According to rules.
Of which-
Yes, it is railway accidents and untoward incidents within prescribed compensation rules 1990. 1990 rules, man. 1990. 1990 rules.
I do not have the, especially rules কি আছে
লাষ্টত থাকিব
Railway what?
বাইদেউ এইখিনি দিয়ক RCT লাষ্টত পাব
Claims what?
Yes, Railway Claims Tribunal Act 1987. man.
Railway claims are-
Railway Claims Tribunal Act 1987. Yes.
Oh, but-
লেটেষ্টটো দিব বাইদেউ
So the rules of 2000?
rules of মাইলত 1990 মাইলত railway accident
Good, yes.
1990.
there is a schedule মাইলত
8 lakhs, yes.
Yes.
Close.
8 lakhs.
That's fixed amount, my lord.
মাইলত the passenger ticket has been in question মাইলত
My
মাইলত
lord,
they are way মাইলত they have মাইলত exhibit মাইলত this is
my
not-
learned friend will submit. Let me finish first. Let me finish. My lord, now we show the provisions of the act.
Fill up a form. They apply for the.
Yes, my lord, format is there for claiming compensation. We filled up, we duly submitted. On that basis, my lord, the case is decided by the tribunal. Now, my lord, I want to show your lordship that provision which wrongly has been applied in our case, which is not relevant. Lordship, kindly
Issue number?
the issue, my lord, this finding has been given in the interim judgment.
issue number 2
Issue number 2.
123 2 of railway.
Yes, railway.
123C2 of railway.
Yes, Railway claimed, Railways Act 1989, my lord. Railways Act
123.
1989.
Actually, this is not the provision.
Yes, we'll show lordship section 123. Section 123.
B3
Railways Act 1989.
B3
I am reading, my lord, section 123. Definitions given here. In this chapter, unless the context otherwise requires, accident means an accident of the nature described in section 124. Now, my lord, dependent. D. Dependent means any of the following relatives. Lordship, kindly take note of this.
Yes.
Dependent means any of the following relatives of a deceased passenger, namely Roman 1, my lord.
Yes.
This provision is applicable to our case.
Yes.
Roman 1. Yes. The wife, husband, son, and daughter, and in case the deceased passenger is unmarried or is a minor, his parent. So, my lord, here it has been said the dependent, no condition. Under this provision, 123B1,
No.
no
that
condition.
Dependent is not questioned in the judgment. I could not find any question of dependent in the judgment.
No, my lord, they have said we have not proved the dependency.
In the judgment?
Yes, in the judgment, the tribunal held that dependency not proved. We should not,
remember.
we need not prove it. Law says clearly we are dependent, son and daughter. But wrongly, the column 2, Roman 2 has been applied in our case, where there is a condition to prove dependency. Wording is altogether different, my lord. Under provision of column 1 and column 2, wordings are completely different. Under 1, there is no condition to prove dependency. Under 2, there is a condition. Claimant have to prove their dependency. But unfortunately, the tribunal has decided our case applying this 2, which is not relevant, which is not applicable to our case. That's what I want to show you also. By applying this wrong provision, our petition has been dismissed, my lord. And my lord, in support of our submissions, we'll rely upon certain judgments, my lord. Yeah. Standing left. Take a look at the video, but it's okay. It can be very good. Wait, come on. Next to view to another. This is another. Future, but it's take a look at the video. Yes. My lord, this is a case decided by Andhra Pradesh High Court. We are relying upon para 3 and 5. Para 3 and 5, your lordship will see. I am reading para 3, my lord.
Yes.
In section 123B, clause 1, the dependents are mentioned as wife, husband, son, and daughter. In subclause 2, it is mentioned that in case of death of a passenger, his parent, minor brother, or unmarried sister, widowed daughter-in-law, and a minor child of a predeceased son, if, my lord, kindly note it, if dependent wholly or partly on the deceased passenger, but similar wording is not used in respect of the relations of the deceased mentioned in subclause 1. So, my lord, wordings are different. Clause 1 and 2, wordings are different.
Yes.
There is a condition in the clause 2, there is a condition they have to prove. Wholly or partly dependent, claimants have to prove. But clause 1, dependents clearly mentioned in the provision itself, no question of proof of dependence. So this is one. Next, question. Rina Devi. Rina Devi. Proceeding on the judgment. Next, my lord, we are relying upon a case, my lord. It is the case of Rina Devi. In this judgment, my lord, we are relying upon paragraph 15.1.
Okay, 15.1.
15.1. Paragraph 15.1, we are relying. My lord, at the middle, we'll read one sentence at the
Yes.
middle of the paragraph. The tribunal must apply the rate applicable as per the rules at the time of making of the order for payment of compensation. My lord, there was different opinion from different judgments, even by different high courts. So there was some confusion regarding the rate of compensation. So it has been finally settled that rate will be applicable as per the rules. Rules in existence at the time of making the award. When the award will be given, at that point of time, the rule in existence will be applicable. As per that rule, compensation should be given. So our case, it is 8 lakh. Yes. I see. Next, my lord, this is also 15.2, my
15.2.
15.2. Yes, my lord, 15.2 also, in the middle, only one sentence. Only one sentence I read.
Okay.
Only one sentence. To compensate for loss of money value on account of lapse of time and for the denial of right to utilize the money when due.
15.2.
15.2. I am reading 15.2
Okay, all right.
in the middle.
Yes, yes.
In the middle. So only one sentence reading will serve the purpose, my lord. So, my lord, because of money value false and denial of right to utilize the money when due, the interest has to be given. Otherwise, the claim will suffer.
Yes, yes.
So that has been made clear by the Honorable Court.
Yes, sir.
Next, my lord, 15.4. 15.4.
Yes.
From beginning, I am reading, my lord, one sentence.
Yes, yes.
15.4. Accordingly, we conclude that compensation will be payable as applicable on the date of the accident with interest as may be considered reasonable from time to time on the same pattern as in accident claim cases. If the amount so calculated is less than the amount prescribed as on the date of the award of the tribunal, the claimant will be entitled to higher of the two amounts. So, my lord, kindly see, there may be two amounts. One as per the schedule, one as per calculated by the tribunal. So, there may be two amounts. Supreme Court has held the higher amount has to be awarded. Clear finding of the court. So, next, my lord, para 18. Another paragraph, my lord, towards the last of the same judgment, paragraph 18, my lord. In the same judgment, paragraph 18, I am reading the middle.
Yes.
We are of the view, court has held, my lord, we are of the view that in absence of any specific statutory provision, interest can be awarded from the date of accident itself, when the liability of the railways arises up to the date of payment. So, my lord, from the date of accident till the date of payment, interest has to be given. This is finding of the Supreme Court. Next, my lord. My lord, another judgment, it is reported in 2008, volume 9, Supreme Court cases 5 to 7. This is the judgment given by the Supreme Court, reported in 2008, volume 9, SCC, 5 to 7. Here, my lord, I will Yes, per initial My lord, here kindly turn to paragraph 11, my lord.
Yes.
I read paragraph 11.
Yes.
Has your lordship got it?
Yes.
No doubt, it is possible that two interpretations can be given to the expression accidental falling of a passenger from a train carrying passengers. The first being that it only applies when a person has actually got inside the train and thereafter falls down from the train. The two situations have been discussed here. One situation, the passenger actually got inside the train, thereafter fell down. This is one situation. The other situation, got inside the train and fall down from the train. While the second situation being that it includes a situation where a person is trying to board the train. When a passenger is trying to board the train and falls down while trying to do so. So, my lord, two situations. Do so. Since the provision for compensation in the Railways Act is a beneficial piece of legislation, in our opinion, it should receive a liberal and wider interpretation and not a narrow and technical one.
Yes, yes.
So, my lord, that has been
Yes,
made clear. My lord, my lord. A small paragraph, 12, my lord, next 12. I am reading 12.
Yes.
It is well settled that if the words used in a beneficial or welfare statute are capable of two constructions, the one which is more in consonance with the object of the act and for the benefit of the person for whom the act was made should be preferred. For whom the act was
Yes.
made for their benefit, yes. It has been made clear by the Supreme Court, my lord. Next, next paragraph, my lord, I'll take your lordship to paragraph 17. Paragraph 17. Paragraph 7. Yes, my lord, I'm reading paragraph 17.
Yes.
Section 124A lays down strict liability or no fault liability in case of railway accidents. Just like motor accident claims
Yes.
tribunal, your lordship, no fault liability. In case of railway accident. Hence, if a case comes within the purview of section 124A, it is wholly irrelevant as to who was at fault.
Okay, I got your point.
My lord, the provision of law is very clear. my lord. If it is covered by 124A, then it is irrelevant who was at fault. Railway was at fault or the deceased was at fault. That is irrelevant. Next, my lord, another judgment. That is also one quantum. Rothi-Menon judgment, your lordship would be knowing. And Rothi-Menon, this is a subsequent case. In Rothi-Menon case also, the similar ruling has been given regarding the quantum interest and the schedule at the time of giving the order, not as per earlier order, earlier schedule. Schedule would be followed which is in existence at the time of making the award.
Now it lacks.
Now, yes.
Give me the.
Now our one is
If you have
8
to
lakhs. Yes. I took good one. So, my lord, meanwhile, your lordship has got the sum and substance of the case,
Yes, yes.
that it is a clean case, my lord. In the railway station itself, accident took place. He received grievous injuries. Railway authority shifted him to the hospital. They have rendered treatment. Everything is as per the records. The tribunal importing personal knowledge on mere surmises, idea, he has dismissed, my lord. So your lordship consider, my.
You're sending council or railways council or
Railway Council,
CTC?
madam. Railway Council, madam.
Railway council.
All pending matter. My lord, the ticket is in question, my lord.
Yes.
My lord, the claimant, my lord, failed to discharge his burden to prove his case, my lord, in the trial court. Well, kindly see, my lord, page number 21, which is, my lord, appeal memo, my lord. The, my lord, deposition, my lord. Made by the claimant, my
Page
lord.
number?
21, my lord.
No. How long will you take?
Only 5 minutes, my lord.
Now, madam. Page number 21.
21, my lord. My lord,
Hmm.
the cross examination, my lord. Cross examination part, my lord. May I read, my lord?
Yes.
The photocopy of the journey ticket, which has been filed by me with original application, has been handed over to me by the police officer who has investigated the case. The original journey ticket has not been filed, although I am filing the original ticket today. I cannot say regarding where about the original journey ticket. It is correct that I have not filed the Sejarlis Jimanama. Bedulipar Health Station is around 100 kilometers from my village. The deceased was a vegetable seller. Journey is also, Jorhat is also around 25 kilometers away from the village. My lord, my lord, ticket, my lord.
Okay.
When my lord, they have, my lord, filed the claim application, my lord, they're supposed to file the original ticket along with the application, my lord.
Under what law?
Under, my lord, section, my lord, 60 of, my lord, Railway Claimant Tribunal Act 1987, my lord, the application, my lord, which they have filed, my lord. The provision, my lord, here, my lord, every application under subsection 1 shall in such a form and be accompanied by such documents or other evidence.
Tribunal?
Section 16, my lord.
1616.
16, my lord.
Yes.
Close to, my lord. There is a prescribed form, my lord. And, my lord, the form, my lord,
Claims tribunal.
Act 1987, my lord.
Okay.
Section 16.
Yes.
My lord. Close to, my lord. Every application under subsequent, my lord. There is a provision, my lord. The evidence on all documents, my lord, the original, they're supposed to file, my lord. At the time of, my lord, which they have claimed, my lord.
Where is the original one? Original word itself is not there. Application should be accompanied by documents, not the original document.
And, my lord, if they fail to, my lord, file the original, my lord, they're supposed to take leave, my lord, to file the, my lord, original in the, my lord, evidence, my lord. Now, my lord, at the time of, my lord, evidence, my lord, they have produced, my lord, the, my lord, ticket, my lord, railway ticket, my lord. And, my lord, they merely said, my lord, the police is handover, my lord. My lord, without filing JIMA, my lord, how they obtain the, my lord, ticket, my lord. And, my lord, also, my lord, they have not produced the JIMA or seizure list, my lord, before the, my lord, trial court. They've failed to discharge their burden to, my lord, prove their claim, my lord. And, my lord, the reasonable, my lord, order passed by the trial court, my lord, this honorable court may not be interfered, my lord. Because, my lord, they have the burden supposed to be discharged, my lord, first, my lord. My only submission is that the ticket is in question.
My lord, what my learned friend right now has submitted, some reply I should give in order to make the things clear.
No, it's okay. I have read it.
My lord,
I have read it. I'll decide it.
my lord, your lordship will consider,
Yes.
because my lord, even the provision given here, CTC as it is cannot be applied. It is a piece of welfare legislation, liberal view should be taken. Supreme Court has said it in series of the next minor 1% more for convenience of your lordship. They have said legal air certificate or succession certificate. My lord will kindly consider succession certificate given by the district magistrate. Your lordship will be named. And legal air certificate given by the government officers, administrative officers, more particularly the revenue officers, given. My lord, your lordship will be knowing, if I submit a petition before the district magistrate for issuing the succession certificate, straight away it will not be issued. They will make inquiry. I have to submit the documents in support of my claim that I am the legal heirs. I succeed. So succession certificate should be given to me. So I have to submit some documents. I have to prove that I am the successor. So succession certificate may be issued in my favor. The records, the documents, the proof which I have to submit before the district magistrate, same things I have submitted here in the claim application. What is wrong, my lord? Same documents on which district magistrate will issue the succession certificate, we have given here. The tribunal may consider everything. Relationship has been proved. So many documents, my lord, school certificate, ration card, birth certificate, metric birth certificate, all we have given. What more the tribunal requires? So, my lord, we leave it to your lordship,
Oblige, my lord.
Other matters will be left over, no time. Third Joint Counsel, Mr.
J. Mullah.
This number, huh?
J. Mullah.
J. Mullah for the petitioner, for the appellant, and the counsel, Mr.
HP Gwala, my lord.
Learned Railway Council, Mr. H.B.
HP Gwala, my lord.
H.P. Bora.
HP Gwala, my lord. I'll
For the respondent, reserve for judgment.
or Mr. BK Das, my lord.
For Mr. Details, Delhi Council and the Railway. Other matters will be left over.
In
I
my-
won't be able to.
Yes, Lordship, I have missed the
perceive
bus,
also.
Lordship.
Oh,
It is the day for
Which
my
was your item?
15, Lordship.
So they are lucky today.
They are lucky today. Lordship, in item 15, I have filed one IA for additional evidence, Lordship. So I have a small prayer, Lordship, keeping pending this regular second appeal here. Additional evidence may be allowed to be adduced by the plaintiff before the learned trial court or first appellate court, as there is a
No,
provision.
no, that I will have to hear out.
Yes, ma'am.
Lordship, then Lordship, after vacation, any date may be fixed.
So vacation date.
Yes,
Date
Lordship.
will go by after vacation, yes.
16 October is a hearing day, Lordship.
November
November, 4th of November.
13.
Oblige. Oblige.